This matter was before Lordship popular on last Thursday. It's a tender matter.
Just pass on the memo.
No, it needs to be little bit hard.
Yes, yes.
No, this should, maybe my request is to take up today along with the item number 15.
Today not possible.
The reason being that your Lordship may kindly hear me for a moment. Thereafter, your Lordship may pass out. Here the matter was there, the tender matter, it was fixed on last Thursday. And stay was not granted and the state was directed to get instruction because of the discrimination and directed to list it today. But the file came at 5, but the list was finalized at 4 p.m. on Friday. That is why it could not be listed. And identical matter today is listed in item number 15 of the different district. So let the matter be called on.
It will be, don't worry. What is a sauce for a gander will be a sauce for a goose. Don't worry. So let us take up 15. If we take up the issues,
that relates to one district, this relates to another district.
I understand. That's why I said.
It become infructuous. The whole point is that today is the last date of submission of the tender.
Let us see.
That is why the Honorable Court directed to list it today. And
We'll
it is
see
not
to it.
now.
We'll see to it. We'll place it on record. Don't worry. Pass on the memo.
Normally, I would not disturb your
Bring the file. Bring the file.
Normally, I would not disturb your question. As a single bench matter, answering of postgraduate doctors have been stayed. So therefore, Mr. Justice Mahapatra has been concerned. Honorable Justice Mahapatra, any other single bench tomorrow, man.
Whatever.
Postgraduate
That is the
counsel-
administrative side, sir. You are a senior counsel, you know. These are all the administrative side matters. You just write. It never happens on a judicial side mentioning is done for that. You just write a letter, we'll do it. And I never keep any file pending. I must, don't give. Give it. Give all the memos, please. Pass on the memos. Write the urgency when you want to be listed. Please write down. Write down.
SLC has posted to 9th, Your Lordship.
Sir, please write down the urgency. When you want the matter to be listed, it will be listed. Please write down. Write down.
During a leave,
Please pass on the memo, whatever. Whatever, please pass on the memo, madam. Yes. Whatever you write that when you want your matter to be listed, it will be listed. Don't worry.
May I have your Lordship if to mention a matter virtually, Your Lordship?
What? Who is mentioning virtually?
Your Lordship, Devanshu Dinda, Your Lordship. It is for EXFA 1 of 2025, Your Lordship. I am for the respondent.
Please pass on the chat box. Please pass on the memo. Yeah, if anybody is here, please pass.
My junior is there. My junior is there.
Yes, please pass on the memo. Yes. Whatever.
Item number 1, WPCL 27 of 2025.
The last occasion, Lordships wanted the victim girl and the parents to be present.
Yes, are they present?
Yes, sir. Yes. But inadvertently, my lord, the father is not here.
Petitioner here. So since the legality and propriety of order passed by the government, before I take my notes to the merits involved in the order.
This is the order, 25th of May,
Right, that is Annexure 1, 21st of May, 21st of May,
Yes.
2024.
Which is the Eviction.
Then Annexure 1 starts from page 20.
This is what is the MGQ's matter.
This is pertaining to license fee. May I take quickly to the issue involved? Your office will see from the license. License was issued on 27/4/2021. Now, 27 date license with retrospective effect 1/4/2020. But that is not for us. Because unless a person has a license,
I do not know, previously the excise rules, which I have encountered in other state. It says that the moment the renewal is, application is made, and is pending before the authority, he has not taken any decision before the expiration, then there will be a deemed extension of the license for a particular period. So if I do not know here whether there is any.
That's a fiction. That's a fiction you're actually proposing. But if you actually see section 18, here the law says,
What he wanted to say is that I got admission on a date, so so during that period,
that
I
section,
understand where he's heading.
That period was shut down.
Is it
Yes.
a shorter period? So definitely the shorter.
no, it's a lockdown shutdown period.
Any judgment on a
I have
major clause?
post measure clause is not applicable. I have one order. I have one order passed by this honorable court in radically placed matter. But of course, the fact may be little different. Let me see. An order.
That is for earlier period.
Page 2 of this order I have handed over. However, fourth line, since there was no license of the law after 1st November 13, consequentially there was no contract, and the petitioner is not bound to pay an excise duty fixed for the above sum.
No, that is why I understood. There the rule was an automatic extension.
that kind of rule is
That
not-
is what I wanted.
But
to know
that
from
is that
you.
kind of rule is not here. And looking at
They have
section
not
8,
taken a decision before the expiration of the period. The
That kind of
application
rule
has
is-
also, it appears that it has to be made 1 month before the
Right.
expiration. If the application is made, then it will be a deemed renewal.
that kind of rule is not here.
Until they communicate the cancellation.
Yes, yes.
of the-
Means I can also operate.
Obviously.
No, it's not there. It's not here.
Lordship may see page.
Okay, 1 second. Kindly see section 18 will also below in addition.
No,
Beg pardon.
during that entire the date from which it was due to be renewed and the actual date of
Renewal.
renewal.
Shop closed. Shop closed. I have not operated.
No,
Rather, Commissioner of Excise recommended my relaxation. If a lordship kindly see
That is
page,
why I say that was the proper way of, so that there cannot be any
gap.
disruption.
right, Lord.
Disruption.
Kindly,
Continue.
kindly see Commissioner's recommendation page
Rule-
67.
Rule,
Not section 18.
section
18.
1(8).
180.
So the license is required.
License is required.
No, it's a mandatory,
Yes.
anywhere.
Yes.
This is a central act.
Right.
Sorry, the state acts, you are done it. Nobody can deny
Grateful.
that there will be a chaotic situation,
Yes.
sir. Everybody will
And,
start sinning.
admittedly, that during that period, I did not.
Rules, whether rules.
It's not there.
anything is-
Not there. No,
Because
it's not there. I'm very sure
applications to
about
be made or something.
I'm very sure about that. Such a rule giving extension is not there. Such a legal fiction is not there.
which one is the portion for renewal?
Renewal.
But you decide-
They do by have a policy
Decide
every year.
Before the expiration.
Renewal.
Kind of
they-
reply, but the Lordship may see page 21,
For-
and it's your one, page 21, the reasons given, your Lordship. Page
So
21.
he says.
They were a licensee of the year 2021, your
So
Lordship.
what he says is that my period of license was going to expire. So as per the rules, before 1 month of the expiration, application has to be made. He said that he made an application.
Yes, your Lordship.
Then you did not process the application for 1 month or more. You processed it in the month of April. That is a fag end of the April, 21st of the
27th of April. 27th of April.
27th of April. Giving a anterior date or retrospective effect of the operation from first of April. So this 26 or 27 days, the interregnum period, they said that they could not operate because there was not a valid license.
Lordship,
So they cannot be paralyzed for this because we are giving a retrospective effect.
your Lordship, for the year 2021, when they were the licensees, your Lordship, they had area dues. That is why when their application, they could not renew the license. When they undertook to pay the area dues in installments before the government, your Lordship, then their license was renewed, your Lordship. That is why the delay was there, your Lordship. because they had area dues, which they had not
That
paid.
is perhaps not reflected at page 21.
It is reflected, Your Lordship, last paragraph of 21. There are two pertinent questions, two grounds that they have done, Your Lordship. And that on the first point, that she is not liable to pay license fee on an NGQ duty from 1/4/2021 to 26/4/2021.
I'm thinking in a different way. What he's saying that if it is a case of a renewal, and the renewal will take effect from the date when you granted.
In the policy, it must be there from 1st April to 31/3/2020.
What is the meaning
I
of the
have-
word renewal? One has to understand. There is a gulf of difference between a renewal and extension of the periods.
Extension is extension.
Extension
Will cover entire thing.
is a continuance or it's a stretching of the original period. But once you say a renewal, if you break the word renewal, what does it mean?
Must be there, Your Lordship. I will see the
What is the
exact
meaning of the word
renewal, Your Lordship, provided all the
Re-
dues are clear.
renewal?
Yes,
What
Your
is the
Lordship.
meaning of the word re? It means again,
Yes, Your Lordship.
and newer means afresh. So it is again afresh.
Again, a fresh, but Your Lordship.
So can it have a retrospective effect?
The excise policy must have, Your Lordship, with the duration, Your Lordship,
No.
of the license. I will check out. I'll file a reply.
You can grant a license for 1 year. If you grant for a mid, then it will be shorter of the 1 year. No difficulty. Is there any bar that it can not be granted shorter to 1 year?
Yes,
It cannot be granted beyond 1 year.
maximum is 3 years.
I file a reply, Your Lordship, with the policy.
Two jargon that struck my mind, that's why I am saying. I mean, the daily development authorization space of 1970 or 71. That is interpreting the word renewal. What does it connote?
71.
70 or 71. I think 1970 was the SSC, if I am not wrong. And second one is probably 1989 Supreme Court. This is the Provas Zoloi. Provas, Provas, SH. V. There the question about what is the meaning of the word extension and renewal?
Those two judgments will I'm educated, I think.
And last line of that, which was assess, business and compliance of 9/4/2020 of this.
And that is for other periods,
Yes.
not for this. My learned friend is missing.
So now, and these are too academic for this. Now tell me that what's your intention?
Not, it is like this. 1920, we asked for exemption on the ground of COVID. We approached the Son of Court. Now, our application, 1920, not three, it covers 3 plans. 20, I'm sorry, 2021. 2021, 21, 22, 22, 20. 2021, we asked for exemption. Now, we approached the Son of Court. Now, after we approached the Son of Court, the Son of Court directed them to consider 2021. Now, they made an installment for 2021. That order I have annexed. So pursuant to that order, I deposited the installments, got it renewed for the next year. Means excise year starts from 1st of April, 31st of March of that particular year. That's the whole excise year. Now 2021, I obeyed the government's order, deposited in installment. 21-22, if Lordship sees that period also is covered here. The same thing. We wanted exemption and representation. Now that representation, which should have been directed before 31st of March, they delayed it by 1905. So the period they have taken for consideration of that representation is the outcome of this. The delay is on their part, not on mine. Despite I have deposited the entire thing in time. That period my learned friend should examine. That is the issue.
Yes. But short affidavit.
Yes, Your Lordship.
Short affidavit. You are continuing with this.
No, shop is now closed. Shop is closed.
Why?
Because after this, he has not been able.
When
Well, it is closed in the to 24, 25, or 23, 24. 24, 25, it is closed. I have not renewed the license anymore.
No, you have not applied.
Not applied.
Yes, but then there is no question of any entry model to be passed at this stage. Because they have not applied for renewal. In that event, you file your affidavit in a short time.
Yes, Your Lordship. No, thanks, Your Lordship.
They are pursuing the demand. Sorry. They are pursuing
The
the,
area dues are there, Your
yes, they are
Lordship.
pursuing.
How pursuing in what manner?
In 21, 22, Your
How
Lordship.
they can realize as a land revenue?
OPDR, yes. They can pursue that. Only this,
No certificate proceedings. have to be
Certificate
taken.
proceeding-
No operational take.
let us wait for.
2 weeks after.
Yeah.
When a notice will come, the certificate officer go by.
24.
Yes,
22.
Consider those things.
Brother, I'll get it.
Item number 4.
The only contingency my learned friend says, not subject to it, permits me, my lord. Only contingency my learned friend says that I'm sorry, Lord. This, if the demand is not somehow or other protected, he will be debarred from participating any future option and any
It's
kind
not
of.
going to happen now. In 2 weeks, we are going to.
Ajay, Lord.
Item number 4.
Over my land, both the matter I came with the law. Withdraw the matter, refile it on the same.
Yeah, exactly. Exactly, filing, so you want to file a thread.
Yes, ma'am.
File
Both the matter.
Liberty to provide a bridge for the citizen.
Item number 5.
I will also be filing the counter affidavit today, Your Lordship. We already prepared it, we'll file it today. We've already identified there are 8 encroachers and they have been served with a G form, Your Lordship. And the previous proceedings has been initiated.
Yes, ma'am. No, last appraisal, you have directed state government to take instruction in whether the land is natural land or not.
I will pardon Your Lordship, we had contacted them and still have no instructions, Your Lordship. May equal to day after tomorrow or Friday, Your Lordship, I will. From collector, yes, Your Lordship. Yes, Your Lordship.
Yes,
By Friday, Your Lordship.
Right.
Right.
Item number 7.
Illegal construction was a land belonging to Jagannath.
Yes, sir.
And I have obtained instruction in this matter. The Government Temple Administration has wrote a letter to the Tahsildar and Sub-Collector Bhadra to take an action regarding this matter. And yes, Mr. Now
Who are the officials who have constructed?
Your Lordship,
He's saying that they are of the resolution. You are seeking appropriate departmental and criminal proceedings to be executed against the officials who constructed such illegal construction. I'm just asking, who are these officials?
Your Lordship, the opposite party number 8 to 10, we have taken a loan.
Who are they? Are they officials?
Your Lordship, they have taken a loan from the Panchayat Samiti. Your Lordship, the loan has been sanctioned by the Panchayat Samiti. Thereafter, they have constructed the mandap.
Whether the Panchayat committee is competent to extend loan? think they are not lending authority, they don't have the power to lend the money. It's either a bank or a financial institution which lends the money. How can the panchayat lend the money? They can give a permission.
Lordship, we have constructed out of MIA land fund through Bhadra Panchayat Samita.
MIA,
Land fund, Your Lordship.
what is the full form of MIA?
Your Lordship. I beg your pardon, Your Lordship, I'm not aware of that. Lordship, I wanted to place a document. This was brought before the sub-collector, Your Lordship. The sub-collector passed the order on 26/3/2025. And the Lordship, if I may please. For eviction of the said building.
When an encroachment proceeding is initiated and eviction order is already passed.
The order, then implement the order.
Yes,
The Tahsildar has not been implementing the same. They've been,
Implement the order.
yes, madam. Notice is given.
No, order is passed, then what more?
Well, as
As notice,
yes, madam, as per OPL Act, madam, 30 days time is to be given to them.
right?
Yes,
If they do not, then,
then they will pay.
so maybe when the order was passed in the month of March,
It was passed in month of May, madam.
no, she said month.
How far was issued on 30th May?
March, 26 March 2025. No, this is the order. 26, give, we have extra copy? What you have? Give my copy. So, reverse page, the penultimate paragraph, look at it. Tahsildar, reverse page. Tahsildar is directed to immediately take steps.
Yes, madam. What I calculate here in this document which the non submitted, it is the proceeding under section 133 CRPC.
Whatever is the schedule of the land is already given, you will not, and they those belong according to how belong to law, they will not.
Yes, madam.
So, schedule of the land is also given.
That is also my instruction from the Tahsil.
Then, why the Tahsildar is not taking the step? And this was in the month of March, now we are,
Already taken step, madam. Already taken step.
when you issue the notice.
What is the directive here?
Yes,
What
madam.
is the direction? Take assistance of the police and do it immediately. So we are in July.
This order was passed on 26/3/2025.
So now we are,
Thereafter, Tahsildar has issued notice on
Sir, it
30th.
is not, because this order has been passed in their presence after hearing them. And once the order is passed, then what more further notice is required that I am going? You are just supposed to implement the order and go there.
Yes, madam. I will take instruction, let's see my.
What instruction? There's the very recurring feature which has happened. Order is very explicit, very clear. It says that Tahsildar, you are there to immediately evict them.
and just to report compliance of. Well, even after 4 months, around 4 months.
On the next week.
This matter or should the director, they'll offer the instruction whether they have taken the grounds, taken in the written note of submission in the input order. But the value of some sort is first July. Right.
Chip, we've received the PWC and we'll be filing the counter actions today itself, Your Lordship.
Have you taken into account the written notes of submission which was made before the?
Yes, Your Lordship will be answering all those points, Your Lordship, in the.
Not improve your case, it will be reflected from your order itself.
Yes, Your Lordship.
Not there.
So
I will be filing a reply, Your Lordship, today itself. Your Lordship.
what's more?
But Your Lordship, there are a lot of other things that have come into, light, Your Lordship.
One has to look at the written notes of submissions and the order passed by the Commissioner of Excise.
There was some duplicate liquor present, Your Lordship, for that.
So
They should
that
protect.
would reflect if there is any reflection of the points which have been, please go with it. If it is, that's a non-application of mine, then we'll have to set aside the order and remit the matter to.
Let the matter
in
come on
consideration.
Thursday, Your Lordship, we are filing it today itself, Your Lordship, will serve a
You
copy.
understand that the answer was not for the authority concerned.
Yes, Your Lordship, I have called them.
You have prepared before, wait, this.
No, Your Lordship, counter will file it today itself. And
Maybe.
You have prepared a counter or who, you are the advocate
we
representative.
will prepare it today and file it, Your Lordship. I have
Your
called the.
instruction must be, what my brother is asking, whether the written note of submission was submitted or filed before the Commissioner of Excise
Yes, but it was hard.
prior to the
Directed
date
and filed.
of, prior to
Next
the
day.
date of hearing, last hearing or an order. We just wanted that.
Exit is also.
Yes, Lord.
Ended,
30th May. 30th.
At page 64. At the foot
Yes,
of that page, a receipt is also appended. 13/5/2025.
We wanted that whether this
Yes.
was that reason we wanted. Huh? Whether this is the genuine one, you received it or not. If you have received, on what date? So then the counter,
It shows that it is received on 35.
Report release, sir.
Yes, Your Lordship, they are getting the records and I will finalize the counter reply today.
what,
Your
what?
Lordship. Your Lordship, without seeing the records, how can I make a submission, Your Lordship? I have.
Produce the record before the court.
I have asked for the records, Your Lordship. They're getting.
Just go through the records, that's the very simple question.
Yes, Your Lordship.
Point is, whether they submitted the written notes of submissions before the Commissioner of Excise on a date as shown there. And if they are submitted prior to the date of the hearing or prior to the date of the order, then from the order, it does not appear that he has taken into consideration any such points. Then in that event, we have to remit the matter to him.
Your Lordship.
Consider,
Your Lordship, Wednesday.
yeah,
Lordship,
you are getting it today,
Today.
we are fixing it tomorrow, go through that. Tomorrow.
Only you. So, that. And satisfy yourself. Whether this. Page 64. Answer 12.
It's a genuine one. Or not.
Is there, that's all, nothing more than that.
Oblige, Your Lordship. Tomorrow, Your Lordship.
Well.
Item 9. Item number 9, sir.
Page 20,
Where is the order of
page 21,
election one?
page 21, election.
Yes, give us 20 seconds. There were certain materials which were found.
This is 600 cubic meters of sand, 100 cubic meters of sand.
1,000 cubic meters of
Sand.
sand.
Stacked without any authority of law, without any authority of law.
You are
I'm a
a
bricklaying
unit.
lawfully established bricklaying unit. I have issued in my favor. I have sitting criteria in my favor. On the question of lease, present lease, sir, I am struggling and one more writ petition is pending in this one. A writ petition is pending on the question of execution of lease or permit in my favor. But today, we are not concerned about that.
No, the concern is that they found
This is what they have found and they have imposed a fine on it.
made a demand.
Right. So the question is, if the whole aspect, the whole stacking, assuming that they are correct, whole stacking comes under purview of Rule 51. Rule 51 of Orissa Minor Mineral Concession Rules 2016. Now, Chief will kindly look at Rule 50. Right. They have to act within the four corners of the statute and in terms of jurisdiction vested in them by law.
Rules.
Nine.
The Orissa Minor Minerals Concession Rules 2016.
60.
Looking at both. Penalty.
Right. Whenever any person is found extracting or transporting any minor mineral or on whose behalf such extraction or transportation is being made otherwise than in accordance with these rules shall be presumed to be party to the illegal extraction or removal of such minor mineral, and every such person shall be punishable with simple imprisonment which may extend to 2 years, or with fine which may extend to 5 lakhs of rupees, or with both, and in case of a continuing contravention with an additional fine of it, let's miss keep it over. Then competent authority is sub-rule Roman 2, competent authority, there is no dispute. 3. No court shall take cognizance of any offence punishable under these rules except upon complaint in writing made by such officer or authority mentioned under clause. Means previous. There are 3 things here. 1. If you are saying that it is completely without any authority of law this stacking, then you are supposed to make a complaint against me before the court. You are not authorized to raise straightway demand against me. 1. 2. The total amount of demand is permissible under Rule 51 is fine is 5 lakhs of rupees. Now you are imposing a demand of 14 lakhs of rupees against me. 3. Now I am saying that this before raising this demand, that I am supposed to be given a show cause notice at least. Because I have documents to demonstrate that these are lawfully extracted materials and I have documents to show I can produce it. On that,
No other provision they can levy some kind of a penalty.
No,
Apart from this criminal liability.
there are 2 aspects. Right.
There is a criminal liability, there may be a civil liability.
Yes.
I'm just talking about any provision relating to civil liability.
But there is no other provision except Rule 51. That is 1. 2. The provision.
In that event, it is only the jurisdictional
Complaint.
magistrate court or
Right.
court who can take cognizance
Right.
of this. Because it is the penalty is a sentencing which is required to be done. Either sentence him for 2 years or you can exonerate him by imposing a penalty.
And there is also a compounding provision.
You can seize the materials, you can take away. How can you permit them to continue with this? Use the law.
If you kindly see page 136.
No,
136.
Under the law.
Well, under the law.
136.
Right, page 136, annexure 90. This unit has been closed from 2024 for want of citing criteria from this collector Baleshwar and so also they don't have the clearance from the state pollution control.
You are not understanding where I think the wavelength of the pulse. There are 2 aspects. You are a statutory authority. You cannot travel beyond the provision of the statute. You have to travel within the provision of the statute. If they have done any illegal mining activities or extraction of the minor minerals without any valid permissions, Rule 51 talks about that they can be prosecuted under the criminal law. Yes. And it is a competent court who can punish them, sentence them. Secondly, you are also empowered to seize the entire material which you found stacked there, so that they may not utilize it. The moment you put these penalties and all everything, that means you are tacitly or impliedly permit them to continue with the activities. Can you do so? My query is this.
Punishable.
It's a punishable. Can an administrative authority pass a order sentencing him? Tell me, under the Indian criminal jurisprudence, Again, apart from court. That is alternative. In lieu of 2 years imprisonment, fine.
Or both is also.
Or both.
Or both is there. And also compounding is also there. Blood sub-rule 4. Compounding is also.
That's why that no
How
covenants
can,
clause.
how can you do it? How can you do it?
Has been passed.
Yes, it has jurisdiction has vested in.
That has been challenged in separate issue.
That is closed. Now, this order under the impugned order that is at annexure 1 is
No,
issued by the.
I am also referring to an annexure 19 at page 136 is where it appears that the closure order is also passed by the Tehsildar. And that is on 19th of December 2024. Prior thereto, there is already amendment that is brought by you conferring jurisdiction upon the. They are not challenging it specifically, just out of the way. I'm just asking.
But it's challenging separately. Challenge.
Anyhow, this demand cannot because the power is not given to you.
Let me take instruction on this.
Understood? So we are staying your demand.
But only I pray day after tomorrow morning.
While you have come, whatever you want to do,
Well,
but don't take any coercive steps. Prevent that.
Only day after tomorrow.
Don't take any
I'll
coercive steps.
But only day after tomorrow I'll
Don't take for.
I'll inform you.
We are adjourned.
Yes. Bye.
Show us any other provisions where you can impose a penalty. None. We have no doubts about it.
Post amendment.
Uh, the legal issue is.
The penalty on answer 4 page 63. The relevant portion is page 65. And test.
It's 63
63 annexure 4.
and it's a 4.
The relevant portion page 65. Where I have been technically disqualified. My aim.
Wrong document, sir.
Fine, I'm sorry.
Yes.
And place. The bidder has not fulfilled all minimum eligibility criteria according to Eviction clause 117 and clause 9 for submission of wrong work experience certificate for substantial completion of work and not extended the bid value.
From where you are reading, sir?
Page 65.
Uh,
Box Mukesh Kumar.
yes. Yes.
The right side. The bidder has not. Findings.
Yes.
I'm placing it. The bidder has not fulfilled all minimum eligibility criteria according to Eviction clause 1.
Sir, if it appears that your experience certificate which you have given is a wrong, then what?
Allow me 117 and clause 9 for the submission of wrong work experience. You will kindly mark wrong work experience.
Correct.
Get for substantial completed
Sir,
work.
I have already read. I am a very fast reader.
Sir, I am extremely sir.
So I am asking you, sir, this is the ground which they have taken. Show us.
There are two grounds.
Wrong work experience for substantial completion of the work
Nice.
and not extended the bid.
That
Then-
is the two grounds.
So-
I have annexed the certificate at the annexure 3 page 62.
Yes,
That is issued by the superintendent engineer.
correct,
Opposite party number 7.
correct.
At this point, your lordship kindly have a glance to page 20.
Mm-hmm.
17.1. Completion of substantial completion of work. I have submitted the certificate where it has been
Sir, which clause?
clause 70.
Don't make the half-baked argument, please.
Sorry.
Samesh, where is that?
Yes. Page 20.
Yes, I am at page 20, which
Serial number 70.
7,
17.
17. Yes.
Clause 1. Similar nature of work as per clause 14.1 of petition.
Correct.
Right side. Completion oblique substantial completion of work of rupees such and such. At this point, your lordship can have glance to page 62 again. The certificate issued by the competent authority.
Yes.
It has been mentioned work experience certificate of substantial completed work. I have filed this document. The second point, your lordship kindly have glance to there therefore two clauses. One clause 9 and clause 117. Your lordship kindly have glance to clause 9 of petition.
Page
34. Sorry, 35.
That's all.
Thank you.
Yes.
Clause 9. All bids received will remain valid for a period as specified in contract data after deadline date for submission of bids and validity of bids. This validity of bids can also be extended
That's a mutual one.
if mutual.
This is a mutual one, sir.
Right.
Both you and the department. Both.
Right. At this point, your lordship kindly again come to page 64.
Yes.
The validity was initially for 820, serial number 21. The validity of tender was up to 28/1/2025.
And further extended up to 27th
So
of
I have
July.
never requested for extended of tender. That's why they are submitting not extended as bid validity. I am again placing the line. Page 65. So that is my first submission. On that ground, rejected. The second submission is that clause 117. They are referring. Your lordship kindly have class to clause 117. Sorry. Page 48, man. Towards bottom, clause 117. May I test? Even qualified criteria met, the bidder can be disqualified.
Understand. There are A, B, C, D. You do not come under A, B, C, D.
Submission of wrong document. Fine. Second submission. They have been proceeding for blacklisting. That is a rule under OPW code. I have annexure 5 and the relevant portion.
So what you are assailing, rejection of your technical, your bid on a technical stage, or you are challenging an order contemplating for your blacklisting.
Blacklisting and forfeiture unit. I am not challenging the tender portion.
Correct. So where is the order?
That is page 64, annexure 4, page 63. Just I place page 65. I am not challenging the tender procedure. I don't want to stall the tender procedure. My limited prayer, my forfeiture will UMD, which is illegal, and they are proceeding for blacklisting, which is also.
Where do I get it?
Last paragraph.
Last paragraph.
Last paragraph of page 65.
Page 65, last two paragraphs. I am placing. After detailed discussion, the committee.
Yes, sir. Yes, I got. What is this? It's not a false declaration of the false. They have said that is a substantial progress. That's a certificate also says is not a fabricated or a forced document.
That is the
Forced document. They may not qualify. That does not mean that they will be blacklisted for that. Tell us.
But see, candidate, page 62 Miller.
Yes.
62 doesn't show Miller whether they have substantially completed.
Sir, the heading is there. Work experience certificate for substantial completed work and they say the last remark column says the work is in progress and satisfactory. Are you saying that this authority, the superintendent engineer of the Sambalpur division, has not issued this particular certificate? Are you contemplating that?
No, he has.
If he has issued, whether it is in conformity with the clause or not conformity with the clause, that's within your domain. You can reject that bid, not in conformity, but that does not mean that he should be penalized for that.
For a moment, can turn to page 36.
Please,
Page 36.
please, show us.
Qualification criteria on general experience.
Correct.
The
That may be a ground for rejection of a bid. Kindly, please, blacklisting has a larger impact on the commercial, the transactions. You cannot do it if you cannot say that this is what the false document or a fabricated document or a false declaration or the fabricated or they have made. All these things, if they have not done it. If it is not in conformity, reject the bid at the technical.
They have rejected.
That's all, finish. Not more than that. How can you proceed for a blacklisting?
Now let's see, kindly come to page 15.
50.
Clause 121.
That is OPW code annexure 5.
Just, yes. 121, clause 121.
121.
Please read.
If
Yes.
submission of false fabricated
Yeah, that is what I am asking, sir. Is it a false certificate? You are also not using the word false. You are saying wrong. How can you proceed for a blacklisting? That's a simple question I'm asking you.
I will take it.
What? The moment the court is the court is not with you, always the instruction is needed. What more? You cannot improve the terms and conditions.
I cannot. Absolutely we can.
It is all documented.
They can disqualify. They have disqualified.
No, this means you can reject the bid. That is what you can do. That's you are not
Never applied for the extension.
you have not applied with in terms of the tender conditions. That's true. You can do it. But how can you blacklist it?
They have recommended for the blacklisting.
How?
Yes.
How? If 121 it does not come under the purview of the F, then you have not verified from, rather you are saying that yes, this is a genuine certificate, but the certificate is not in conformity with our requirement. You can definitely reject the bid at the time, you reject it. He is saying that I am not, but how can you go for it? No, sir, it can't.
121F, you are
referring.
121F.
Yes.
That's not your case. That's not your case.
We are watching that particular portion where you contemplate it.
May I pray one thing, but since I follow this matter day after tomorrow, so that on
No.
that point I will take this.
Sorry, you can't. You can't go by this. Stop. D'accord.
Second prayer.
Sorry, the recommendation portion has gone. Then recommendation was both for forfeiture as well as the blacklisting. What more? The forfeiture is a fallout of the blacklisting.
Then may I submit a representation to that effect?
Oh, you have been given a fullest of.
Sorry, well, but
That's item number 11.
I was a eligible bidder participating.
You are an ineligible bidder.
I'm an eligible bidder.
Eligible.
I could not participate without why because. Because my see page 26 of my petition. PDF page 31.
Page
26 of my petition.
what is the ground?
Because here it says role of So,
Maybe tender matter penalty.
that's page 26 clause 2.6.1.
One, yes.
It says that I have to drop the bid as per the portal e-procurement software and web pages of Government of Orissa. That is A. Now I'm reading it out. Customize e-procurement software and web pages of Government of Orissa bracket the 10th site to enable the provision for electronic payment. The NIC will Orissa will modify/rectify the errors in electronic data relating to the chart of accounts. NIC will provide an interface. That is C. Further minutes I'm not there. My C is my case. NIC will provide an interface to organization to download the electronic receipt data. Now let me see annexure 2.
Page
minutes 54. I'm interested to participate in the bid. I prepared the documents. This is an affidavit that is required to be filed along with the bid. Certain other documents. It continues till page minutes 16. I'm sorry, minutes 62 minutes.
yes.
Then minutes page 63 is very crucial. I submit the EMD with the intention of participating. Now, on that day, the day I submit my EMD, I try to upload my documents in the e-portal. Next page, annexure 4. I cannot upload the documents. Resultantly, annexure 4, there's page 64. On the last day of submission of bid, I intimate see there are technical issues. I issue a mail. The relevant page is at page 65. Intimating the tender evaluating authorities that there is some problem. I am not able to submit my EMD as well as my bid, technical bid. I also said that other contractors are facing such problems. Now, next page. This is a proof that there is an error. Page 67. The next page, I will also given the EMD submission certificate. Now, what they do in return, annexure 5, page 68. They admit that certain other bidders are also suffering the same problem. They admit that they have been intimidated of such problems. They issue a letter to the opposite number 4, that is NIC, to find out whether such problems are being suffered by those bidders. After that, closure of all documents.
Then whatever they have written to DDG and SIA to make a confirmation.
Yes.
Yes, there was any technical glitch.
Yes. They have not replied. I am not on the premise.
what happened? Then
That's not
whether
what
the
they have
PDG and SIO has given?
Yet not given any reply. The tendering authorities have not given any reply. What they have done, I have thrown out of the participation. What they have done, one bidder had participated. Now I am told that 2 bidders have participated and the tender has been opened. So if this problem exists and competitiveness is being hampered, they should have at least taken the impetus of the upper part number 4, that is the National Information Center. And my only prayer is not, I'm not in any way interested in infringing the tender proceeding. I am saying that if the lacuna comes, the DDG says that yes, there is a problem, then the entire tender process has to be quashed.
That's the kind of a glance to page 28.
28.
2
Yes, yes.
Clause 3.5.7.
Correct.
The tender inviting officer is not responsible for any failure, malfunction or breakdown of the electronic
No, that is the tender inviting officer. But if somebody is not permitted to participate in it, that's a disclaimer which you have done that I will not be responsible. If there appears to be a technical problems, and if many intending bidders were prevented from participating, then do you think that in a tender or a public contract, when you invited the bid, so why was there any other letters which was received from any other corner apart from
Yes.
apart from him?
Only stated in that letter, Miller, that
Because it appears that on the same day, he has given you a mail.
the same day after that.
I have seen 7:19 p.m. I have seen, but they must be trying before 5 because that was a deadline before 5.
That's why NIC is maintaining that way.
Sir, the difficulty is that when they were attempting, if they are attempting prior to 5, then certainly they are within the time.
That's why I need instruction on this.
This is, you take instruction and give it, because we wanted whether any reply has come from your technical side, NIC.
Today I was inquiring, NIC has not given any reply.
If there is a technical, then it says.
If it is at that end,
then you can't. It's not an open one.
That the settle or that is suppose it is. Yes,
And if they have already done it, all the RTGS and all everything.
Yes, madam, that document is there.
So
that's if allow us 2 weeks time. 1 week.
Till that moment, the tender
there's a chill on 4th, they have already done the RTG. So that shows a strong presumption in their favor that a person who has remitted the money on 4th will not submit a document within the time on 5th.
They must be trying.
He must be trying one after another and desperately doing that.
Whether that technical needs existed in that server or not, we have to.
We have to, and then if it is there, then we'll have to.
Yes.
Because the money has gone to you. Through RTGS.
So that's it. That 7 days time will progress.
And don't proceed for that. Don't proceed to issue a work order. What is the tender for?
Obstruction of road minutes.
So don't issue a work order.
That's the fix of a date.
Sir, then we are passing an interim order, not to issue a work order.
I will inform the department.
We are believing you, and then we are giving you time. Yes. 1 week to take instruction. He's saying now we remember.
Because similarly, another contractor has also come before this honorable court. It is 17228. That may be tagged and done next day. It may be brought to place.
What is that item?
It is not there today in the list, but WPC number.
You just give, it will appear on that day.
Item number 12.
Wait.
Yes, sir.
Last order. After Miller to file a comprehensive chronological event in relation to the litigation. Because there are some confusing facts which could not be placed before Miller properly. I have given my lord a comprehensive. I tried to make it. Lordship, my lord, in the sense, my lord, the entire facts will be before my lord.
Your Lordship, the doctrine was on Friday, fourth, Your Lordship. So I received not only document, but just a chronological date chart, Your Lordship. Of
What?
a chronological date chart, but it's not in the proper form like a memo of Your Lordship. I have not been able to do it because before was the lottery and the officer.
If my lord will go through these chronological events, my lord can reach a conclusion how my lord the petitioner has been subjected or victimized by the authorities.
Why?
But I am coming to that.
The lottery is per chance.
No, lottery, madam. Lottery, I'm not challenging the lottery. I'm challenging the way I have been victimized by the authorities because I was bit, madam, a lot about my things, madam. What has actually happened in this case, madam? First, I was allotted, madam, in the year 2021. Still, I got license.
What you are challenging here?
Here I am challenging Annexure 22.
What for?
That is the lottery, madam.
So you
But
are
the
saying
order-
you are not
order-
against the
order-
lottery,
order is
you are not
annexure-
challenging the lottery, now you are saying.
I'm challenging the order dated by order passed by the opposite party number 3 under Annexure 18. I don't think I see that. Before,
So you are challenging a lottery because they wanted to do it for through lottery. So
Annexure 18 is the order which was passed by opposite party number 3 rejecting my representation. Before going to that, my lord, I just want to draw my lord's kind attention to some facts. If my lord will see the facts, my lord will reach at a conclusion, my lord, I believe my lord will reach at a conclusion that I have been victimized in this case. How?
no, what is a victimization, sir?
Victimization is, my lord,
Means
first,
what?
my lord, the order was passed by this honorable court. My lord, order Annexure 3, my lord, kindly see. That I have stated in my comprehensive note at paragraph 4. My lord, kindly see. Considering the grievance, order was passed. Page 3, paragraph 5. The
Page,
grievance of the petitioner is that
page what? Annexure 3.
Annexure 3, by the way.
Yes, this is the
Page 37.
39. Okay.
Order was passed on 19/1/2023. I have stated so in paragraph 5 of my comprehensive note because the last occasion, my lord was pleased to direct us to give the prayer and to give the order. And accordingly, my lord, I have prepared it my comprehensive note in that line. My lord, you see, the grievance of the petitioner is that having been forced to close his shop due to public pressure, he should not be asked to deposit the duty of the executive during the closure period. In a similar matter, an order was passed by this court in 5th November 2021 in so and so, where on account of admitted position that the shop in question was closed on account of opposition by the public, the licensee was not held liable to pay the executive duty during the closure period. In terms thereof, a direction is issued directing the state government to consider the application of the petitioner dated 25th March 2022 under Annexure 18 for not being asked to deposit the executive duty for the closure period and communicate the decision.
Why the court then said when the decision has already been taken in the earlier writ petition not to insist for that, then merely the authority is a rubber stamp authority. He can't go beyond that.
They have not done so till date.
What?
With regards to the MGQ or the payment required, they have not deducted it from till date. They have not carried out this order passed.
Means your representation dated.
That has not yet been disposed of.
No, dated 25th March.
Calculating it.
25th March 2022. That representation is still pending. I am asking you this question.
That is pending, my lord, as per their.
They have not taken any decision
Not
on
taken
that.
decision. And that is being multiplied time to time. And my lord, on the last occasion also, next order, my lord, may kindly see at page 17. What was the prayer and what is the order? WPC number 10519 of 2023. That is annexure 4, but I have quoted it, my lord. Prayer and the order which was passed, the matter is taken up through hybrid mode, paragraph 8. Third, the petitioner has filed this petition seeking direction for the renewal of license and for granting permission to carry forward.
So the next order dated
My-
6/4/2023
My lord.
in effect dilutes the earlier order of 19/1/2023.
My lord,
The next order of 6/4 has really virtually diluted the earlier order of 19/1/2023.
my lord,
Diluted.
My lord, diluted.
So
But
now
as per
it is
this
a
order-
fresh order.
Well, as per this order, I deposited the amount.
Correct.
Yes. On well, this order
And
was
then
passed.
the
this order-
shortfall was carried forward to the next financial year.
Yes, but the order,
Then-
this order was passed on 6/4/2023.
Correct, sir.
I deposited the requisite amount on 8/4/2023,
Correct.
and my license was renewed.
Correct.
And I lifted the MGQ, but in paragraph 10, I have stated categorically what was the MGQ which I lifted and what was the money I deposited. Then, my lord, I continued. I draw the attention of the authorities that in the shops, black marketing is going on, or the spurious liquors are being sold, but the superintendent has not taken care of, charge officer has not taken care of, though my lord statute is very clear that they should see all these things. Whatever it may be, my lord, on 31/3/2024, my last day, I closed my shop, I returned back, but the next day, on 1/6, so 1/4, my lord, I found it fine morning, again, next day morning, I found that my shop has been sealed. And I received a letter from the superintendent that you have to lift the rest amount. I said, how can I live if my shop is sealed? Where I will keep it? It is again illegality. How can I commit that illegality? After that, my lord, the issue continues. My lord, may kindly see. My lord, paragraph 14. Paragraph 14.
You decided to close your.
No. My lord, they sealed it.
Under what?
1/4. I have given that, my lord. My lord may say.
What for? What was the reason?
No reason, man.
Reason for non-lifting.
They say you have not lifted the required MGQ.
Correct.
It should have been spread over.
Correct.
I was ready to do that.
You could have deposited the money and say that now I have deposited, I am ready. You please remove the seal. Let me.
But let me see. But I have done that. But they did.
Did you
accept my
deposit
request.
the amount for the shortfall after the seal was put?
They sealed it.
Seal. They put the seal there.
My lord.
Did you deposit?
And directed me.
You deposit.
And directed me to lift the.
Lift means you'll have to deposit the money.
My lord.
For this shortfall.
Yes. I said you deduct the amount.
Sir?
You deduct the.
Did you deposited the amount and then pray for removal of the seal so that you can get the material and sell it?
No, my lord. What actually happened here? I tried my best to convince them you would just deduct the amount 8 lakh for 8 months, then the amount which has been directed by the Honorable Court. They remained silent. They didn't pay any hint to it.
Who could not get the
I got the information now, my lord, that big desperate, my lord, I applied for under RTI, and they said we have wiped out.
Yeah.
We have wiped out that period, but calculating the same.
Not been deducted from the.
And that has not been deducted till then. Well, that is annexure.
Annexure 17, page 112.
Ballot basic 112.
Page 112.
112.
What is this?
Well, for no reason I am suffering.
Annex 17, page 112, ballot DC. Column 5, serial number 5. But till date, they have not deducted this amount.
No, deducted the amount, but what for? They need deduction. They simply say that for this period, they have waived the closer period.
Yes, but they are charging it. They are charging it. They're charging
Where is
it
the charge? Where is the charge?
Well, the collector has said it towards the last part of 13 crores amount, and while arrangement also.
Where is the order? Which page?
Annex 19, page 128, the order part by the collector, opposite per note, please. Page 128.
That is relating to
Declare as
23,
order for
24.
non-depositing the amount.
23, 24.
Whether
Waiver was for 8 months till December,
From April to December,
April to
December.
April to December 2024.
From 5/4/2021 to 2012/2021.
And this is for a period of 2023-24, much after, not concerning 2021.
well, this is pilot for the entire period they are saying.
No, sir. This is for the year 2023-24.
No matter they are calculating it.
No, that is your perception that they are calculating. But this is not a perception. They simply say towards the short drawn NGQ of such and such by the end of financial year 2023-24.
Pilot they kindly see.
For the year 23-24.
Pilot they kindly see annexure 18. They have categorically that is pilot they see. 121. Granting permission to one.
And the
They are
page 129 last paragraph
pilot.
that confines 24-25.
That is what it says.
They say in the here
Non-deposit of demand of accessibility.
this order has not been, I should not say by the collector is not G. Malik, but one G. Malik has passed this order.
Yes. Look at shortfall of the. At a different place. One can be closed by a public option. All the three were not closed. They are at different place.
One yes, Paladin in Balason district, three places.
Whatever the objection was in relation to one place. Then what about the other?
Other
Pattapada and Balaram.
And Balarambadi.
Then what happened? There is also a shortfall and there is a demand.
I have drawn the attention of the opposite party number 3, but to draw everything within a period of 3 months.
Not everything. Wow, how can you club together? Each unit has a different.
All the 3 units, I am ready to operate, paying 300% of the demand they are making. 40 crores property security I am ready to give, and also ready to pay 2 crores in each month. 2 crores per for consecutively three, my lord, any amount they want to,
We don't.
they want to, my lord.
This is not the. File your counter, we are not going to. Have you filed your counter comprehensive short bits? File your counter. Put it on affidavits. We are not satisfied with the conditions. Put on affidavits, counter. 4 weeks, one week for rejoinder. Matter to appear after 5 weeks.
Support matter.
This case, which is from the parallel, order that this is dispose my reprehensions. But annexure 2, my lord, this Raman collector pass order, running to 22, my lord, first para, the collector notice to appear on equity user purchase, charge for public purchase, by parent, as the word petition was not available, but that is a false pleading. The notice not issued by the collector, my lord. The annexure 3, my lord, the petition was so much. Sir, if you are not available, the affixation was done, what more can be done? What more you expect? My responsibility, my lord, annexure 3, my lord, I am so much appear and filed by written pleading, my lord. That is not also reflected. When you appeared, after the order is passed or when you filed it? This Sumoto 7-2. 7-2. And this is order is dated thereafter. 25/4/2025, my lord. That is a annexure 3, my lord. The collector also granted a receipt also, my lord. Show us. The land is recorded as Hata.
Marketplace.
Heart. Say heart.
Heart.
Yes. So heart. My lord, 100 years ago, my lord. The record of right, my lord, annexure 4, the market, the Hatta, the village Hatta was around 100 years ago, my lord. Now how Tahsildar evicted, my lord, can you see annexure? That was recorded. How many people are there in the Hatta?
Here part happens, number of shopkeepers they were occupying the shop.
Okay.
Eviction notice, the proceeding was initiated against all of them.
Then
Many persons they challenged the eviction notice for this honorable court for the honorable single judge. Honorable single judge referred the matter to the Tahsildar for reconsideration. Now, this person who has filed the public interest litigation is challenging the eviction virtually.
okay.
Now he is not affected. And number two, that the honorable court directed.
He is one of them. Public interest litigation has been filed by him.
He has filed public interest. This is the public interest litigation.
He was not before the.
How can you pass a public interest litigation? Who are you? Are you one of the occupant? Are you one of the occupant? My lord, the Honorable High Court. I am asking you, sir, are you a occupant? My lord, the Honorable High Court in past instance, Mr. Sarang and advocate appeared on behalf of the British submit that is the client is the social worker and duly authorized by the shopkeeper and resides of the village Nuaga and other adjoining villagers in the Sundargarh to move this court against the eviction notice. Let us see period 2024. Can you do that? PIL lies. I am asking you. I do not know it was entertained whether the PIL lies. These are all the activation of law. If somebody is aggrieved, let him come. No, sir. Sorry, we can't. Maybe if they have given a notice, if they have adjudicated, if they have passed an order, let the person who is affected by that order come and challenge it. Who are you to challenge it? Where is a public element involved? Show us, where is the public element involved? My lord, this is a village hut. Sir, village hut. If there is an illegal occupant and there is a law in place which says that they have to initiate a proceeding, they have initiated a proceeding. If order is passed, whether legal, illegal, the peoples against whom the order is passed, they will challenge it. What is the public element involved? Public interest litigation. Show us. Nearby,
No market complaints.
Where is their shortfall
My lord,
that this is what their constitutional obligation?
No.
They are not fulfilling this constitutional obligation.
My lord, if the
Sorry.
auto was abolished.
Now I'm very strict on the PIL. I have seen here the PIL is being,
My lord, I will take further instruction.
sorry, we can't. No,
Next week or-
we are dismissing this.
My lord,
You go and let them challenge the order,
my lord, one
but not in the way of PIL.
Next week also, one opportunity.
No, sir.
Giving further
No, sir.
instruction, my lord.
Just give it to me. Put day after tomorrow. I will dictate with all the judgments of the PIL that what does it mean. I will dictate it so that henceforth at least the PIL is not entertained in this way. Just give it to me. I have those judgments with me. Day after tomorrow, you just give it to me. I will come day after tomorrow.
Item 14.
Day after tomorrow. Yes. On the prayer of the petitioner, with this matter, day after.
Before I go to the interim order, I just run through the dates now. The tender was floated in January 2024, and the closing date was 15th of this February 2024. I became the successful in that. Work order, letter of award has been issued in my favor. And then work order was issued in my favor. After that, a writ application has been filed. Filed by another person who is not a bidder, nothing. Stating that Your Lordship, I can directly take to that writ application.
No, then what? Challenging that particular.
Challenging the tender condition.
Correct.
He is not a bidder, never participated.
Whatever.
Is challenging the tender condition. Now that writ application was dismissed, saying
Correct.
that it renders infructuous.
Correct.
Then after that, another writ application for the self-same prayer was filed
By whom?
by the same person.
Correct.
Then an order was passed that a representation to be disposed of. Tendency in the guise of disposing the representation, he now said tender is invalid, the collector has said. When I
Where
have
is the order?
order is at the annex 1, page 26. And I can just page 25.
There was already an interim order.
Interim order that this
Well,
tendency.
you did not tell us that there was an interim order not to finalize the tender.
Final is not.
No agreement pursuant to the tender.
My agreement has not been executed.
Sir, that means what?
Work order has been already.
That means no finalization.
No, finalization has occurred. These are formal situation of agreement. Your Lordship can, in the same order itself. May I just take your Lordship? It is already, the work order has been issued and I am working. Both in the previous writ application, the same prayer, it was held infructuous.
You were included there
My lord, I was
in that writ petition.
Yes, my lord. Yes, my lord.
Why you did not challenge
Which one?
that the work order has already been issued?
My lord, that is noted down in that order.
Where in the High Court's order?
Your Lordship, 119, Your Lordship,
120.
120.
Paragraph 4.
Paragraph 4. And in fact, I fortunate my friend was there, he is also instructed. Paragraph 4. Mr. Tripathi will on an additional government submitted in the meantime. Work order is pursuant to Annex 7 has already been issued by the collector, Baleswar. In view of the above, nothing
No,
remains.
sir, I am not talking about this. I am talking about the order of the High Court, which is quoted in the impugned order. That is subsequent.
There, I have not filed my count.
Where is that writ petition and where is the order?
That order is at page
Subsequent second writ petition.
146. Page 146, man.
Yes.
That is the.
In here also at paragraph 2, work order has already been issued in its favor, but no agreement has been signed.
No, that is a. Oh. The matter is still pending?
Yes, madam.
Go there,
No, it's before your lordship. The lordship can tag this matter that
tag it.
and till that
Tag. No, till date.
No.
Tag it. It has been cancelled, nothing more than that.
No,
Tag it.
cancel. It has the
Sir, the interim order is staring at your face. Interim order
That is
is
an
staring
expiring
at
order.
your face. You are a party to that writ petition. We will not stay the operation of the impugned order.
May I submit my letter?
No, sir.
That
If you want, I'm just dictating the order. If you want rejection of your prayer for interim order.
I'm not, ma'am, what I'm
So
submitting.
please tag it. Let the matter appear after a week. Let us see both the matters.
But I've given the reference number.
Please, this is the reference number is WPC number 9616 of 2025.
Yes, ma'am.
Let it be tagged.
Yes.
Come.
Item number 15.
Mr. Tripathi, you can also verify the status of consideration of representation as directed in the interim order in that report. Page 148, page 41, 148, para 4.
No, this is earlier matter.
Yes.
Huh.
The Honorable Court directed to.
That also be ready with that on the date.
15.
Yes, 15.
Well, this is the matter. Here, your lordship, on my mention, your lordship has called for the earlier writ petition 18040 of 2025. That matter was taken up on 3/7/25.
I could not get it, sir.
On my mention, the another matter which was supposed to be listed here could not be listed.
Look,
I made a mention and your lordship directed to get the record.
have you got the record? Which one?
The orders, you'll also can see the order number 1, 3/7/2025.
Who are you here?
And the petitioner, madam.
I know. What is the name?
K. Ravi.
So this is the another writ petition. 18040 is also by K. Ravi.
This
You're the same petitioner who has filed the instant writ petition.
No. Here is the different petition. Identical matters, but petitioners are different. Districts are different.
You are a Baldev Prasad Kormi.
This relates to the one which is district by lordship. This relates to one district. The tender notice issue, and this.
But I have not read the brief.
That is what I'm saying.
That's why I'm asking. I do not know the facts. What for it is done, I have not gone. Can you please precisely tell me the facts? That what is the fact and what is the point involved and why this is the reference is necessary?
This matter because the stay was not there and his lordship directed to list it today.
What is the subject matter of challenge in the
issue tender notice annexure 4 is under challenge here, particularly the clause 9.1, 10.4 and 8.1 of the impugned tender notice annexure 4. On the ground
tender notice is at page 24.
Clauses 9.1, 10.4 and 8.1.
Which page? Sir?
Page manager, you'll automatically see the 8.1 is that page 19, 42.
Page
of page
42.
You're also holding the brief of 18040 or 15.
I'm holding the brief 18300.
Oh. So 42, man.
Yes. Yes, what is that?
The bidder shall have minimum 2 number of transport vehicles installed with GPS enabled vehicle location tracking device registered in his or her name. Additional requirement of vehicles install GPS enabled vehicle location tracking such and such can be availed on higher basis.
Correct.
The next clause is that you also can see Schedule 9.1 is next page 43.
Yes.
This is the schedule given for fixation of rate,
Correct.
and they have fixed the rate on the page 9. The
They have said that 19.46 PQ for 0 to 8 kilometers.
yes, accordingly they have fixed at the rate of rupees 41 to 43. 41 one block and 31 rupees something in one block.
Where do I get it?
Madam,
Where do I get it?
your lordship kindly see that is page 98. Birmarajpur block is 41.11 and Torba block is Dungripari block is 31.17. Then your lordship kindly see the letter in page 186. Another clause is there, but before going there, since it is relates to rate and relevant.
No, what is your grievance now?
Six.
186.
186 Annex 6. There are 3 schemes sponsored by the government, Union of India, regarding that free food.
That is 150.
Madam,
That is fixed at 150.
50. In all, there are out of 3 schemes, the government is paying, and the direction was given much before the tender notice was issued.
You had seen that now they have floated it.
So Union of India gives money to the state, and through the state agencies, they used to call tender notice for transportation of food grains for Anganwadi worker, for midday school, and to Panchayat to distribute free. So for the same routes, same transport vehicles, same type transport vehicles, these are all there. In January 2025, under Annexure 6, government has issued a letter enhancing the transportation charge 100 up to 150 per quintal from 75. And the other scheme also is there, midday, the Prime Minister midday.
So yes, they have enhanced then.
Yes, but in the tender in question, they have fixed it to be 37 and 41 rupees in exorbitantly low, without any basis, even though they might be receiving money, the same money, transportation charges from the Union of India. But when it is spent through the state agencies, they have reduced it arbitrarily in one scheme out of the 3 schemes. And the another clause is there, that is your lordship kindly see. There was a lottery system previously, it was prevailing. Now they have changed it to a clause that if all the tenderers will be of the same value, then the tenderer who has given taken the highest number of transportation unit, that is blocks, they will be given, which was is reintroduced with the oblique motive, keeping someone who had taken more number of units in the previous tender, that is 2023-24, 24-25, given, whereas it was there earlier in the earlier tender lottery. Because why they say Lord, just for survival, even though they give a very low price, all the tenderer used to give the lowest price, below which they cannot quote, and the tender will be rejected. So in that case, they used to do lottery. That your lordship can receive the that is there in the previous tender.
This
Civil Supply Corporation, you have instructions to appear here, no? Or notice has to go?
My in fact, I have been instructed. Miss Pragya Manti is there. I am online, madam.
Mr. Mishra, are you appearing?
Madam, I have been instructed by Miss Pragya Manti to appear.
copy has been served.
No copy has not been given. The matter has come for the first time, and
Not the copy.
The another that clause your lordship can see.
Sir, we have.
Odisha State Civil.
We do not want to make them wise. What we notice, let them come with the stand. Let us see on the next thing.
Your lordship formally issue notice. I will serve copy to them.
Please, we are issuing.
Yes.
Mr. Mishra, District Magistrate come Civil Supply Officer.
My lord, I have a small submission to my lord. They made the cabinet secretary a party, but the cabinet secretary no role to play. So you may be deleted and issue notice to the estate.
Why you deprive yourself?
My lord, it is not an issue, but only this cabinet secretary no role to play.
Oh.
And I heard from
So
this.
they made a party, no difficulty. You have no negligible role to play, no difficulty.
My lord, if you go through the government made the direct petition, he will know the answer where it will go. If my lord discuss with me, I can make him explain also.
Might have some ministry, the food civil supply or any other ministry maybe, but
May not be a necessary, but a proper party.
Yes.
No difficult.
Yes. They are the person who is paying money to the state. It's
Whatever, so proper party, their presence is necessary.
2-3. 2-3.
So Mr. Mishra waives the notice. The service has to be
4-5.
formal notice.
4-5 euros.
Four, 5 and 6. 4, 5 and 6.
Serve them a copy.
Chairman.
Man, that will go to the state. That 6 will be by the state.
No, 6 notice has to go. 6, Mr. Mishra, are you appearing?
My friend Mr. Das Saswat, Mr. Saswat, the government council will appear.
Collector, tender committee, you are appearing. 236. 4-5, Mr. Mishra. 1, Mr. Pari.
So 2, 3, 4 copy not necessary. 1 is also not necessary.
Copies of reproduction is
For
served on.
5 and 6, I will serve 2 copies if necessary.
Huh.
2 copies.
Adequate numbers of copies will.
5 and 6, 2. Rest other the copy has already served. No further copy has to be given.
For 4 years to give a copy, madam.
For 4 and 5, my grand senior lead.
Yes. I will serve copy to her.
Yes.
Let that be interim stay, my lord. Today is the last day of submission of tender. Otherwise, the repetition become infructuous. It will become infructuous. That's why I with the
Let them, finalization has not been done, we'll see to it. Finalization has not been, if it is,
no financial.
if it is shocking to the conscience that they are not adhering to it, it will go, don't worry. We are fixing this matter when?
The point of worry is the only thing, my lord. I
have seen that letter which you are relying on.
No, the tender date is today.
If you want, I can make them wise because they will come with the answer. So the query is very limited.
Without fees, they should not be wise, man.
So that's why we say when it is coming. When it is coming. Next week it is, let it be kept.
Today is the last day.
Any action taken shall be subject to the result of the writ.
Or can we get also of that they shall not finalize anything because tomorrow only to whom they intend to give, tomorrow they will give.
Let us see. That thing comes, nepotism, we will be there. We are here. Don't worry. Yes.
With that observation, I have got nothing but to in both the cases, we will take together.
Yes. Do it. All the next. All the next.
Mr. Das will.
Definitely. Take it.
Item number 16.
Similar order. In the corresponding incident.
Yes. Next.
Item 22.
Discuss. Petition of penalty annex 1 is imposition of service tax that is 38,59,714. Petition has no trade or business, any business trade or outside of the tax. And the imposition of tax that is illegal. When the petitioner know first time know that
You must have suffered one assessment order. You have not challenged it.
that I am
This
The recovery notice
is only recovery notice.
How can it?
It must emanate from. It must have emanating from assessment order. So order in original you have not questioned. So long as that is that exists, we can't do anything.
that only I have got from the bank.
So then you'll have to take steps somewhere, sir. They have simply given a notice to recover. And this amount is liable to be recovered on the basis of an earlier adjudication. The assessment order has been passed. Means finding that you are liable to pay. Now in the recovery, what we will do? Can we say illegal?
That only they debited my bank because 2 lakhs and that is the amount is without any notice they report.
Sir, they have given you a notice. They have given you a notice that the assessment order has already been given. We wanted to recover it from you. They have given you a notice.
There is no.
So you have not.
But you have suffered an assessment order. You are not challenging the assessment order. That assessment order is staring at your face, sir. So where is it wrong?
So your implication of parties are also mistake. Assistant Commissioner, Government of India, there is no post. Assistant Commissioner, Government of India, Ministry of Finance, Department of Revenue, there is no post. There is no authority. There is no authority. Opposite party number 1.
Yes.
And Senior Intelligence Officer, DGGI,
Only with single point notification. I made him the passenger.
there is no post also.
Lordship, no
Senior Intelligence Officer is there, DGGI.
no copy has been served to us. Let him serve the copy to us.
What to do, sir? Can we, on what ground? You are taking a ground which may be available to you when you challenge the original order. How can it be?
Sir,
Tell us.
in a taxation matter, assessments, in assessment you have to participate. If you have not participated, it's all right. Assessment order is passed. That assessment order is carried to appellate forum. If you have not challenged here also. Pursuant to that assessment order, demand is raised. That demand recovery notice has been served upon you, or the through bank. The authorities have taken recourse of bank to recover that amount from your bank, since you have not deposited that, you have not satisfied that demand. So there must have been some assessment order. Till you challenge that. There is no pleading also.
What you will do with this? Tell us. The defect of parties, even your right, there is no ground justifying the interference with this notice of recovery. What to do, sir?
Can these notifications I am challenging?
There must be a ground, sir. Mere challenge does not mean that it has to be caused. There should be a valid ground. You are saying that you were not given a notice. That in relation to an assessment order. Can we reopen the assessment order, which is not a subject matter of challenge? So tell us what to do. Otherwise, we proceed to dictate the order. There is a defect of parties as well.
Better you withdraw and take proper steps. Whatever you decide.
File.
Memo. File a memo.
Liberty.
So, better particulars.
Let's call the next.
Item number 23.
Cancellation. A cancellation of registration.
Yes.
Item 24.
Same.
Let's cancel it.
Yes.
Corrected?
Yes.
Item number 25.
May I please, your lords? My lord, this matter was already made by my lord Justice RAMAN, right? But after the change of assignment, this order was passed. The order of
This
the-
matter was heard by my brother.
My lord, it's court number 14. My lord has already heard the
And single bench.
single. My lord, here your lordship. The order dated 21.
Sorry, should not deal-
Is under challenge, your lordship.
I should not.
No.
be part
But
of
after
this.
assignment, this order was passed by my Lord Justice BP Rao. Your worship kindly peruse. the
Just
annex
1
number
minute.
And placing before your lordship at page 11 and 11 portion at page 13 your worship.
Just. What? What is the wrong in the order? Tell us.
My lord, here your lordship kindly peruse my read petition annexure 3. Prior to that, your lordship, kindly peruse my appointment order under annexure 1, your lordship.
Is it
By
a
the
regular? It is a regular appointment or a
Yes.
temporary appointment?
That person who has got the appointment, that was also, he has also got the similar type of the order. And he has
Where is that?
I have made an application that was not considered till now. I have
That
already
is a
entered
different issue.
some-
That's a different issue.
My lord. Here, your lordship, kindly
Show
peruse.
us that show us.
My appointment order is not for 44 days, your lordship. I was engaged for 100 days. Thereafter,
Please
continuing.
show us your letter of appointment, sir, and the letter of appointment of a co-accused, both.
Yes, that one not with me, the co-accused. But he was deputed.
Show me your letter of, this is the erection 1 to the writ petition.
My lord, kindly peruse my additional affidavit, your lordship. That was. in the-
What's your name?
My
I
name,
mean, the petitioner's name.
Nicholas Elias, Nicholas Khosrow.
Correct. So the appointment letter is at page 12 of the writ petition.
My lord, kindly peruse. Your lordship, I was engaged. I was at the selection committee. As per
Contractual
my-
appointment,
My appointment was, sir. My lord,
contractual,
virtual attendant at ADAPT existing vacancy, your lordship, my lord, for 1 year, period from 1 year. Last line, my lord. Not for the 44 days, your lordship. My lord, single judge has taken in the judgment.
and where is the engagement letter?
Engagement letter, your lordship, it is period, annexure 1, at page 12, your lordship, my lord.
Yes,
I'm
there other co-accused.
I have
appointment.
not, I have not.
They must have disclosed in the counter.
Counter simply against me, my lord, but they have not stated anything regarding the other court, Nagarjuna Acharya. He was also with me at the time the criminal proceeding. I was acquitted, he was also acquitted. What his case was considered, and now he is enjoying the service with all the benefit, your lordship. My reputation was, my representation was rejected, and despite my lord's order to consider my application as per the court did not consider, your lordship. Thereafter, I filed the second writ petition that was also rejected on the ground that your lordship.
Next, just 6 to the writ petition. That is the order by virtue of which Nilapanta Khosla was reinstated.
Nicholas, not Nilapanta Kunda.
Nilapanta.
Nicholas Khosla.
Is the petition. Now here appellant. Appellant name is Nicholas Khosla.
You are making out a case of a discrimination. Will you not produce the documents?
Because my lord, I tried to
What wrong?
I obtained the right to obtain.
Sorry.
But was not considered, will not supplied by me.
Whatever. It is up to you what you do. It's up to you.
My lord, here, your lordship, so many cases, my lord said decided after acquittal.
Sir, in respect of a regular employee, we appreciate it. He is saying that the other person was a regular employee in employment. Then in that event, I'm conscious of the proposition of law originating. The first case is M. Paul Anthony. And thereafter, the subsequent judgment, GM Tank, and whatever. There are other cases where says acquittal from a criminal case will impact the departmental proceeding also, and then can go. But here is a case that your contractual service was terminated by a notice.
Question regarding the end of service, your lordship. Similar decision, your lordship, kindly prevention. Honorable Supreme Court already decided the case, your lordship, in connection with the other replacing the
Eskasi.
Yes, your lordship. No, my lord. Babulal versus the state of Haryana and others. Report in AIR 1991 Supreme Court.
Sir, you are talking about 91, sir. I am talking about subsequent there too.
But specifically,
those have been diluted subsequently. There has been a departure from this stand. The concept of honorable acquittal, the concept of technical acquittal, the concept of acquittal in evidence of certain evidence that has been taken into consideration. And a very recent judgment of 2024 or 25 has also come. 23. So you are stuck up in 1991, sir.
No,
much water has already flown in the river.
And in case of Avatar Singh, they have summarized the principle, what is to be done.
So what can be done, sir? Show us that you are a permanent employee. You are entitled to.
I will try to
nothing. You can't improve a case. This is an appeal.
My lord, I will got the try to.
This is an appeal.
Appointment of the.
No, not required. Finding we cannot challenge. Finding we can't challenge.
There are 38 theological guides. There are 38. We have noticed various decisions and tried to explain and reconcile them as far as possible. In view of the aforesaid discussion, we summarize our conclusion. Thus, Lordship, I will take your Lordship to straight away to 38.5. In case where the employee has made declaration truthful of concluded criminal case, the employer still has a right to consider the antecedents and cannot be compelled to appoint the candidate. And the recent judgment of Supreme Court, that is in 2023, that is by Justice Bella Trivedi and Ajay Rastogi. They are also. They have taken note of Avatar C, para 30. Prior to that, they have also taken note of all the previous judgments of the Supreme Court. Person against whom he is claiming discrimination, that person, he was put under suspension. And that order of his reinstatement, he has enclosed with the additional affidavit that is that has come along with the writ petition. He was a regular employee.
I am also suspended. Annexure 2 is declared. First go through the annexure 2, thereafter then you have rationalized. I am not. I am also suspended. Annexure 2 is declared.
Additional affidavit?
Additional affidavit, my lord, filed by the petitioner
Yes.
on 10/7/2024 in the writ petition. Page 3, your lordship, of that affidavit, that Sri Navudan Achari, pharmacist, CHC, Narayan Patna, was under suspension in the office order dated being involved in the criminal case. Subsequent upon, he was found not guilty by the Sessions Koraput in the judgment dated so and so, being convinced his above period of suspension from so and so is regularized and the duty period with full pay is due.
Oh, he's a permanent employee.
No, my lord.
What is
That person was also selected by the selection committee. Thereafter, he was regularized.
You were not regularized.
After 6 years you have practiced, you have got
No.
My lord. Now, this is the letter. This is the engagement order, your lordship. May kindly peruse my appointment order as well as the order of suspension, your lordship. Annexure 1 and 2 is before my lord. I was also suspended. I was also engaged for 1 year. Then I continue since 10 years, your lordship, without any objection, without any complaint. That person has created the disturbance.
In counter affidavit, our specific case was that he was initially appointed on 44 days basis.
No,
Granted extension.
No.
In 2015, my lordship, my kind is counter affidavit.
Then it's difficult because the appointment letter does not talk about the 44 days service. We have gone through the appointment letter. It does not talk about the 44 days service.
They have enclosed the documents.
Sure, you produce the document relating to the appointment and regularization of that particular person. You take instructions and give those documents. Produce that document. Yes. The
May it please your lordship. My lord, in fact, this matter was before your lordship on 15th of May, my lord.
We have filed two affidavits in both the cases. We have served copy also through mail. I have served copy of the council.
Okay.
And that was served today only because the affidavits were filed on Friday. And those affidavits have also not come on my lord's board. It's not reflected in the list. May I pray if it can be taken up next week if we get so that they can also go through the.
Yes. You have been served with the additional affidavit today.
My lord, maybe in the court, our associate advocate. Then we'll see. You will see that.
Mr. Patnaik.
Yes, my lord.
Since they have sent via mail, email,
WhatsApp. Sorry, WhatsApp. To Miss Suma Patnaik.
Miss,
No, I don't.
No.
We'll go through, my lord.
Mr. Patnaik.
Yes.
Miss Suma Patnaik's WhatsApp has that document.
Oh, I see, my lord.
Yes.
And
So therefore, your lordship may call it next week or sometime after.
Yes, next week.
Ma'am.
Only caught that. Copy has been served.
Some copy of the additional affidavit stated to have been filed by additional government advocates has been served by electronic mode. List is register may also keep the taken attached they said the additional affidavits at the appropriate place.
Right. Item 27.
Item 27, may I please? Item 27. Item 27, my lord, it is the previous writ appeal where objection I had received from my learned senior regarding the writ appeals drafts and all. My lord, I had filed for just to assist the court. My lord, I had filed an IA for amendment where after going through the objection filed by my learned senior, there were certain paragraphs that were pointed out in respect of that. I considered to assist the court. If my lord will not allow, I will present the case from the brief from the judgment. But the case in respect of amendment is that I have only deleted the paragraphs that my learned senior pointed out that she feels that I had borrowed it from the writ. I only deleted without changing the nature and character of the case. I have only sought for certain deletion of certain paragraph. If it is allowed, then the case will.
Then what would remain in the writ? Still the cause of action survives.
Well, the cause, I will stick to my prayer. I will stick to my merit. I will stick to my IA. I will press all the entire matter from the judgment. I will show the discrepancies in the judgment, not the draft. My lord, I already acknowledge that I have done some mistake, and I have only sought for deletion. I have not changed the pen. I will stick to whatever is in the case. After receiving the amendment was filed on Friday, my lord. So I have.
They want a deletion.
We do not know if he wants a deletion. I do not know what deletion he wants. I have to.
Sir, I will say honestly that because after verification, both the sides fact is the same. It is inclining. Both the sides fact is the same. I have taken some fact only because my learned senior had made such a. I just wanted to learn the language.
They might interpret or construe those as an admission on your part.
Admission that I have done some. I had tried to take the language which is factually both sides is correct. I could not have written better than that. I would have written the same thing, my lord. But
I know the admissions in the. That's the point.
Admission is I only because it was
Withdrawal of the admission by way of an amendment. How far?
Amendment is I'm seeking only deletion. I am not changing.
That means the withdrawal. That I said the deletion means what? Withdrawal of an admission.
My senior was affected by what I do, so that is why I am apologetic for.
So you serve the copy. You just go through it.
We are also filing an affidavit, but there is a development meanwhile. the imbued annexure which was there before the single judge, the annexure which he supports, the members who had signed it, some of them have written to our society that it was taken through not a very good practice. So to that extent, I have to file that affidavit that might have a bearing. But the annexure that he supports now and the members who have signed it, they are saying that it was taken by practicing misrepresentation of facts and fraud. We've written to that and we are filing an affidavit to that extent also. I will also serve the copy. This is just
Serve the copy, a copy of an amendment
So my humble
to the writ petition is taken out, by the writ petitioner, by the
before my friends class, I take for pause one moment. This is a case poorly covers, my lord. Shastri has been declared as equivalent to BA. I succeed. Shastri has been declared as equivalent to BA. Shastri is a subject, which my lord has given the judgment in Smruti Rekha case. I succeeded before the honorable single judge. Now government has come of appeal.
which one?
I have given a citation before my lord's board. Shastri has been declared as equivalent to BA, referring to equivalence degree as recognized by document dated 31, my lord's judgment, 31/7/2012.
It is a single bench.
Single bench, my lord's judgment. My lord.
How can you
My lord?
division?
I
That
have
was
given
not
the citation.
challenged. That judgment was not challenged.
No, not challenged yet.
Implemented. Implemented.
Yes, implemented. In Smruti Rekha case, I succeeded on a single judge. Now government come up with appeal. Particularly this point on the subject.
Some judgments and
Yes, my lord.
I respectfully differ. What to do now?
we have split views.
What to do now?
What I have done in single bench, I may not agree to.
Then
I'll take time, my lord. I want time, I will satisfy also.
I have a right to dissent.
Yes, my lord.
So,
I have a right to verify judgment also if it is wrong. My lord points out the wrong committed by me while delivering that judgment in single bench. Then I'm subject to correction. I'm a very I get sail in the same boat.
Let it come next week, I will.
Maharaj, you are ready with the matter.
Yes, yes, my lord. Let him submit my brother. I am the opposite party here, I am the respondent here.
Oh, you have.
I am the respondent.
His right to begin.
Right. That is why I beg pause for a moment for my brother. Just to first I look in the Shastri has been declared as equivalent to BA. That is my case was before honorable single judge. I succeeded there. Yes, my brother can start now. I'm sorry.
Saying the boomerang when you hijack the right to begin.
No, my lord. Just my lord. Just my lord.
Boomerang.
No. I'm sorry.
The covered case. Authority covered case in a division.
Division means?
Citing single bench judgment. How can you say that this is covered in division?
Yes, it has been covered by the division. I don't. Yes, I don't know the number, but the covered or not, I don't know. But my lord has given that has been not implemented yet. That has not been implemented, sir. Because it is a.
Maybe implemented, but they have the right to challenge in subsequent cases. Are they precluded?
But here the issue is not equivalency. Here issue is different. Here issue is whether the petitioner fulfills the eligibility criteria as prescribed under the advertisement. So also under the resolution. Now your lordship may kindly see the government resolution basing on which the recruitment was carried out. That is at page 70. Page 70, 70. 27/10/2014. Recruitment procedure of teaching staff. Page 70. 70.
The counter.
The advertisement that is that was annexed to the counter. Page 70 is the resolution basing on which the process of selection has been carried out.
Is a resolution?
Yes. 70. Now, eligibility criteria, that is at clause 1. Then your lordship will find 3. Before that, I'll just place 1C. Candidates having bachelor's degree in arts, commerce, and science with bachelor's degree in education from any university of the state or its equivalency are eligible. Regarding universities, institutions of outside state, these candidates shall only be eligible. We are not concerned with that. Now, your lordship may kindly come to 3, the educational qualification. In the present case, we are concerned with recruitment of Hindi teacher. That is at page 72F. Hindi teacher. Bachelor's degree from a recognized university with Hindi as one of the elective subject with minimum 50% of mark in aggregate, 45% for SC, ST, PH, OBC and SCBC candidates, or with Rashtrabhasha Ratna from Rashtrabhasha Prachar Samiti, Wardha, or with Shastri from Odisha Rashtrabhasha Parishad. Now, what is the requirement? That you must have a graduation, and with the graduation, you must have the other qualification. Means either you have in the graduation an elective subject of Hindi,
This is what your authority interprets it.
But that is the
what is the importance of the disjunctive word used there? What it says?
It says or with your lordship, the Rashtrabhasha Ratna and Shastri is preceded by the word with. With means
graduation with Rashtrabhasha Ratna, graduation with Shastri. So graduation, the mandatory requirement is if you are an unreserved candidate.
Any university have said that the graduation with Rashtrabhasha Ratna, and that too from a different institution. Can you include it? I am asking. Suppose a person does not take the Hindi.
Yes.
He takes a Rashtrabhasha Ratna.
Yes.
Can this be a subject, elective subject in the bachelor's degree course? I have not come across in my career.
Well, here what the advertisement says,
The advertisement, please look at it. The first, when you talk about the advertisement, 1C says that equivalency is also eligible.
yes,
It says that candidate having a bachelor's degree in arts, commerce, and science with bachelor's degree in education from any university of the state or its equivalencies are eligible.
yes.
First, equivalency concept that comes. Later on, then it says that in case of the Hindi teacher, it says that the bachelor's degree from a recognized university with Hindi as one of the elective subjects, with minimum 50% marks in aggregate, 45 for the reserved category. That is one. Then say or with Rashtrabhasha Ratna from Rashtrabhasha Prachar Samiti, Varda, or with Shastri.
That is another.
Or with Shastri from Odisha Rashtrabhasha Parishad Puri, or with Snataka acquired by June such and such, date of such and such, from Hindi Sakho Samiti.
Yes. Here, my lord, here the petitioner in graduation, has secured less than 45% of marks.
That's a different, but this is the
although he has Shastri qualification,
whatever, then he has less than 50% marks.
yes, he has 50%, less than 50% mark. Pursuant to the advertisement, initially he didn't offer his candidature. Subsequently, when extension was given to all age bar candidates, although he was within the age, he applied subsequently. His application was taken into consideration, but when he was not allowed for document verification, he approached this honorable court, and pursuant to the direction of this honorable court, he was called for document verification. And during document verification, it was found that he has secured less than 45% of mark in graduation.
And what the single bench said.
So single bench, what the single bench has said, your lordship may kindly see the judgment. That is at page 90 is the relevant portion.
What has been held?
It has been held. This court, after going through the mark sheet available under Annexure 9, finds that the petitioner has secured 428 marks out of 700 marks in Shastri examination, which is equivalent to +3. Since the petitioner has secured more than 61% in his graduation. Graduation means Shastri.
That's true.
Shastri.
That's true.
The ground on which the claim of the petitioner has been rejected as per the considered view of this court is
saying. If the Shastri is considered as an independent equivalent, the eligibility criteria, then in that event, if he has secured more than 50% marks, he is eligible.
But as per the rules, it is a requirement with the graduation. It cannot be taken as an independent subject matter.
It can't be. The purpose is
and moreover,
then the meaning of the disjunctive word and the intention equivalence, that has to be.
And moreover, the best suited requirement, qualification, age, and equivalency is concerned.
I think in Eviction Shastri is declared equal to graduation.
Yes.
Isn't it?
Where are the materials which shows that the Shastri is equivalent to graduation? These are the.
You must be knowing. You must be knowing.
You also put a very good question, my lord. My lord, I am referring to equivalence degree as recognized.
That is our single bench. I don't know. Eviction is distinct.
But two cases which has been relied on by the honorable single judge in present judgment. In one case, the SLP is pending, in another case, the writ appeal is pending, and both the cases belongs to training qualification. And those cases have no precedential value so far as the subject is concerned, but however, those cases have been considered.
Your requirements are very clear.
And moreover,
Your requirements are very clear.
and so far as
When
equivalency
you
is
talk
concerned,
about
the lordship,
Snatak, what does it mean? Snatak means a graduation.
and equivalency, whether it can be declared by the court, that is also another question. Your lordship.
Court cannot say that it is equivalent to a graduation. No.
Yes, but here what has happened? The court has said so.
I have also heard it is within the domain of the government or within the domain of the education institutions whether to recognize any degree equivalent to this. Question is, when the advertisements are very clear and its interpretation has to be made, here you have not really thrown out that the Sastri cannot apply. What you say is that this interpretation shows that the Sastri is recognized in conjunction with the graduation to be done from the university.
Yes.
But then requires an interpretation that your advertisement makes the Sastri independent or dependent upon the graduation. That's the interpretation.
Yes.
We are not going to say that Sastri is equivalent to graduation. Then we'll have to say that what is the effect of the word or used
succeeded by with, preceded the Sastri, preceded by with, or the word or succeeded by with.
That is what I'm saying. What you are saying, that there must be some symmetry which should be found out. I do not find any kind of a situation like this. What is the meaning of the words bachelor's degree from a recognized university with Hindi? You are putting emphasis on the word with. I understand. With Hindi as one of the elective subjects. With, again, minimum 50% marks in aggregate. This is one. Where one of the elective subjects should be Hindi, total marks should be 50%. Correct. Correct. Then you say, or with the Rashtrabhasa Ratna.
With Rashtrabhasa Ratna means?
With what has to be. No, you are putting this emphasis. With the Rashtrabhasa Ratna from Rashtrabhasa Prachar Samiti. Vardha. Yes. Then. Or with the Sastri from Odisha Rashtrabhasa Parishad. Yes, Puri. Or with the Snatak within bracket acquired by June 2005. The date up to which the temporary recognition has been granted from Hindi Shiksha Samiti, Orissa, Cuttack, or an equivalent degree from a recognized institution with at least 50% marks in aggregate. And Hindi Shiksha Parangar from Kendriya Hindi Sansthan, Agra /DHED, a course prescribed by NCT, then from the institution recognized by NCT and affiliated to a recognized university /DHED in Hindi, a course prescribed by NCT from Dakhin Bharat Hindi Prachar Sabha, Madras, a institution recognized by NCT and affiliated to a recognized. Then you have said, or big, and then separate paragraph. Bachelor's degree with Hindi as one of the optional / honors subject with minimum 50% marks in aggregate and any in Hindi with minimum 50% marks in aggregate from a recognized university. Now, if you have put two categories, and the second category is restricted to a degree course only, without any variations, without any relaxations. And then you say MA is also included if somebody has done it. Then the first paragraph where you have expanded the eligibility criteria has to be considered that bachelor degree is must or it is one of the eligibility criteria along with the other eligibility.
Your Lordship may kindly see that or, that big or.
Or
After that, it is written bachelor's degree with Hindi as one of the optional subject, honors subject with minimum 50% of mark in
this is
aggregate.
one category.
This is one category and
Then
MA.
or
And MA.
with or with.
Yes.
That is what is given.
Bachelor's degree with, and here it is written
No.
or with.
There is no comma after bachelor's degree. Sometimes the punctuation also
Yes.
plays some importance in interpretation of the statutory provision. Sorry, sir.
But my lord, my respectable submission, my lord, whether the court can declare the equivalency. But your lordship,
I have said that this is not a question arises here. We can say in very bold letters. Had it been a case that the court is going to decide the equivalency, I tell you, my own judgments are there where I have heard no, the court's pulse is not so wide. But here is a case which requires simple interpretation, not equivalence. Whether the bachelor degree is sine qua non or it is one of the conditions, along with other conditions are also there, which are independent to that. So Sastri you have included. The question is that a person must have a Sastri along with the bachelor's degree or the Sastri independent of the bachelor's degree. That's the question.
that is the only question, my lord.
That's all. No equivalence.
But the advertisement
You
as
interpret it.
that advertisement, that word Sastri is preceded by with. So once it is with,
That is what I'm
then it
saying.
has to be read
If grammatical
conjunctively with the
mistake,
graduation.
if the grammatical mistake comes, what can be done? Had there been a comma before with Hindi, I would have understood. You will not put a comma before Hindi.
But the condition stipulated in the advertisement has never been challenged before this court. Your lordship may kindly appreciate.
Advantage of it, sir.
Yes.
But he's taking advantage. He is not challenging. He says that you have misread your advertisement. The correct reading of the advertisement is like this. That is his step. It's a question how you look at the glass filled with, I think, half filled with water. How you look at it. That's the only thing. Sorry.
Only your lordship may consider.
No adjournment.
No, I am not praying for adjournment. I am only saying that your lordship may consider that he was an applicant under the untrained category. He was not a trained candidate. He doesn't have a training qualification.
Whether the single judge has said so or said that he's a
No,
trained or
that was our case before the single judge encounter also.
Single judge says
the single judge has only referred to the percentage of mark. And
now you treat him, if you have treated him as an untrained, you will treat him as an untrained.
And moreover, after this recruitment, 3 other recruitments have been completed. And whereas vacancy and the list, the select list, those have already.
Now, what I find is that the word with is snatak, acquired by June, snatak means a graduation.
The Sastri is the grammar.
Please look at it. Sastri was there, and thereafter you have also included with snatak.
Mr. Das.
Snatak means a graduation. Page 73, second line. Or with snatak, acquired by June 2002. Snatak means a bachelor. How can there be a 2 bachelor?
Yes, ma'am. Before my lord, in board my lord, I have filed citations.
Notification you are referring, right? Where is that notification?
Page 3, my lord, in citation. It is clearly para 3.2. Yes. Have you got that? Show us. My brother is saying that there is one notification he relied in his judgment. Where is that notification? You are not ready. So you are referring the judgment. When I have judgment, my brother says that he has referred a notification. Yes, I have already.
Where is that notification?
I have already filed my lord. That is my lord list that is citation is there. अच्छी फाइल कर दी थी केस
इंडियन कानून का जो सूची से डिस्टॉर्टेड लिख रहा है और ठीक जन सारा देवें
इसे बताइए
This.
There's such laws, there's such.
Next one, develop from the BID.
City has already notified equivalence. And my brother has relied, that is on 31st of July 2012, this equivalence has been given. Odisha Rashtra Bhasha Parishad Puri Rashtra Bhasha Sastri with the +3 Hindi pass.
Yes, that's it. Can I
What is given? So if there is an equivalence which is given, then what more?
I conducted cases.
He has quoted, my brother has quoted in his judgment. We wanted that particular notification.
Lordship, I know. Your Lordship allows me, can I go through that judgment? If the Lordship may keep it for tomorrow or day after.
Come tomorrow.
Not
What is?
Item 29.
May Lordship kindly turn to Annexure 1, which is impugned in this appeal. Will turn to page 23. Starts from page 21. Will turn to page 23. This petition filed by the auction purchaser, being the participated in the auction process by the bank, and being the highest bidder, deposited the entire amount 1,37,64,056 before the bank. And before that, the original borrower, who is the respondent 2 here, and the bank Miller. He filed an application before the DRT challenging the securitization proceeding Miller initiated by the bank. There, the London DRT Miller directed a conditional order. You will kindly turn to page 24. Next page, that order is quoted, DRT order. In view of the submission made above, as the applicant is ready to deposit 1.5 lakhs. 1.5 lakhs is direction given to the borrower to deposit. Within 3 months from the date of settlement and to meet the ends of justice, this tribunal direct the respondent bank to proceed for auction sale schedule on 25/3/24. But the same shall not be confirmed without the leave of this tribunal. Appellant is directed to deposit 35 lakhs and 70 lakhs. So this was the conditional order granted. So borrower obtained an interim order and he has deposited through the auction process. Now this was at the session of the tribunal. When the matter at the session before the tribunal, my lord, the auction purchaser came before this honorable court, before the London single judge, my lord, and the honorable single judge directed the bank to refund the amount with 12% commercial interest. When the matter is still pending before the London tribunal, if you are, and he participated before the tribunal, arrayed as a party.
You are the bank.
I am for the bank. Madam, kindly turn to page 26.
They deposited this 35 lakhs and
Yes, the borrower has deposited 1.5.
Now before the auction, now the latest Supreme Court judgment, what it says that the borrower's right does not get diminished.
Yes, borrower has deposited below. Now problem is below.
He can come before the sale, before the proclamation of the sale. He can come and then deposit. And if he satisfies all the dues, the decretal amount, then you are bound to
Yes, we can.
It's a question ago, the moment they initiated the proceeding, the right of redemption, then they were responsible. So they cannot come, but now they just say that before the proclamation of the sale, or even the sale to be continued, the borrower has a right to do it when deposit.
Borrower has deposited, my lord. Now problem is, your lordship, here, I am saying that when this matter is before the learned tribunal and participate both all parties.
Or you want to hold the money?
No, we have proceeded pursuant to the, we are not there to hold the money because the matter is still sub judice before the learned tribunal. If you lordship see for a moment, page 26.
Have you given a notice?
Yes, your lordship kindly turn page 4. Yes, I will be ready to pay back. We are ready to pay back.
The single judge has passed an order for the refund of the
Your
money.
rate petition.
Yes,
You
sir.
file a rate
Yes,
petition.
sir. Yeah, please, your lordship.
Page 26, your lordship. Page 26, paragraph 10.
It just says that the tribunal should dispose of the matter within 15 days from the presentation.
It is.
And then say that in the event if the tribunal decided to cancel it, the entire process, then you'll have to pay the interest at the rate of 12%. It is not immediate payment has to be done.
No, my lord, tribunal has not yet disposed of the matter. It was, tribunal still continue with the matter. And in the meanwhile,
Please come to paragraph 10.
yes,
Court was conscious that the matter is pending before the tribunal. Court says that the peculiar facts and circumstances, we are directing the DRT to take up the matter and complete the hearing of the case and pass an appropriate order within 15 days.
not yet.
The date of the presentation of the certificate.
Yes, not yet. They have not, bank has not, tribunal has not yet.
The tribunal is bound.
He has not, my lord. My humble submission before my lord is that with this
It is also
12%.
directed, there has been others waiting for a long time. And then confirm the same along with 12% in the date of the order of the tribunal.
Yes, that 12%, if you are similar, in the auction process, in the tender notice, if you are see for a moment, it is, if you are see that tender notice, it is floated in the tender, that is well known to the purchaser. Plot, my lord, may kindly turn to page 47.
Sir, at the time of cancelling the proclamation of sale, the DRT may impose certain costs which you have incurred for this, that may include this. This is not the case where, sir.
We only.
When somebody borrows the money, one day default attracts the full penalty for
Yes,
you.
my lord.
And here, because of you,
No,
if they have paid you a money, the money is kept with you.
Yes.
You have utilized the money. Will you not pay the usufruct?
Your lordship, my lord, we have kept the money because we cannot pay because of the DRT direction. DRT directed to proceed with the matter without finalization. That's why the money is with us. Problem is that, my lord, we are ready to pay the amount immediately, but that 12% interest which your lordship, the honorable court had directed, that is restricted to page 47, you see, my lord, for a moment, clause 31. It is open, it is a tender through e-auction, my lord. Here in the event, you may read, my lord, page column 31 of that tender notice, my lord. So that was not considered by the honorable single judge, my lord. Honorable single judge proceeded the matter when the matter at the session in the DRT. Of the parallel proceeding.
Whether the writ against the order of the DRT lies.
Yes, it's not like, it's not maintainable, my lord.
It's not. Give you a judgment of the Supreme Court says that the High Court enjoys a power of superintendence over the DRT. If the power of superintendence, like Article 227, can be exercised over the court and the tribunal, when they come under that, then the High Court order has a.
My humble submission before your lordship is that how can the two parallel proceeding initiated at the same time? Yes, my lord, because in the
refund, as the refund of the amount, which is lying idle with you, Is this particular proceeding continued for 5 years?
Yes,
What will happen? Where-
that's why the Honorable Singular directed the tribunal to dispose of the matter within such a particular period. It is not yet been disposed of.
They are not, then let him exercise the power of security.
If you see the Annexure 10 series, my lord, only problem is we are ready to pay, but the matter is still pending before the DRT. DRT is not hearing the matter. Annexure 10 series, I have given the entire order sheet. How this is lingering matter? We have not lingered. Because see the 10 series annexure base starts from page.
Who is the respondent number 2 here?
The respondent 2 is the borrower.
Respondent number 1.
One is the petitioner in the
Issue notice on the respondent number 2, let it come.
copy may be served. I will serve.
Serve the copy.
Can I pray for the interim?
Or convince at all.
So if your lordship see the documents, certain documents I have annexed,
Nothing.
those documents shows that it is lingered at their behalf.
Sorry.
Paid the amount, it's been more than a year.
I understand. Get it, get the copy. Give them a copy, notice of the respondent. 2 weeks.
Item number 30.
It is.
Speaker to take admission to class 6 in the Adarsh Vidyalaya, Anandapur.
Is it a high school?
In the Adarsh Vidyalaya.
A government school?
Yes, a government school. Well, Adarsh Vidyalaya,
Anandapur?
Anandapur.
Or it's a private?
No, it's a government. It is a government organization, my lord. The government organization Adarsh Vidyalaya this is the only establishment of Adarsh Vidyalaya in all blocks. In the 314 blocks in the state, my lord. It is separate status, but it's the organization of the government.
Why you want in class 6 admission?
My lord, class 6 admission because only she is entitled to the benefit under clause 6 and 12 of the guideline, my lord, which she has been deprived of. Because she is the ward of the employee of the Adarsh Vidyalaya. She is a daughter of the teacher of Adarsh Vidyalaya, which has been enumerated in the, my lord, in the guideline. Only may I draw your lordship's attention to the guideline for a moment. That is, your lordship see, page, that is clause 6, my lord. Clause 6 at page 24 under annexure 1. Only the collector and district magistrate as the chairman of the management
Procedural for
committee.
Which one? Which clause?
My lord, 6 VI 20, page 24. Page 24 of the guideline. My lord, that is the 6 VI. It is a collector. May I read, my lord?
Which order you are challenging?
Only once.
I'm asking you.
Yes. Which order, my lord? This honorable single judge.
17 June order you are challenging.
Honor annexure 7, my lord.
I am asking 17 June order you are challenging.
Yes, 17/6. Because the honorable single judge did not entertain my the I and did not was only put up this matter. This is that's in September, which will be deemed to be infructuous. Because this is the academic session and it starts from this minor zone only. The admission will start and if it will be taken up under a term and without
Admission starts from.
minor
Academic section will start from.
first this July, in the month of July. Admission will be completed by this time and this July.
Is appearing for other school.
State, my lord.
Other school.
Other secretary is state.
No.
Yeah, this is the collector. Collector is the chairman and is the other secretary in the academic in the admission selection committee and also the other.
Session has already begun.
Yeah, started, man. Now admission is going up and the also vacancies are available and she is entitled to.
You have to. You can't represent two. Can you represent two?
Who, my lord?
No. Notice you can't represent. You also cannot represent six.
This.
When six are really interrelated. You will notice 56 and come back after the.
Well, once vacancy may seat may be reserved, otherwise it will be infructuous.
So after 2 weeks.
Right. And I filed the I. 5, my lord, otherwise it will be infructuous.
Item 31.
My lord, one seat.
Right.
Yes.
State for orders, but it was mutually agreed that we are argued on merits, both on limitation and merits. That is how my limit principle.
It's judgment in case of Arun. But that judgment will cover the aspect. That is what fact that regularization of service. So, but here, so far as the petitioner, he is claiming parity. The respondent is claiming parity with 8 others, those who have been regularized. Now, they have been given appointment prior to the cutoff date because the ban period was imposed by the state government. Now, they were given appointment prior to the ban period and that is why they were regularized. But so far as the petitioner is concerned, the respondent is concerned, he was given appointment after the ban period. So that is why, so far as a NMR and a DLR employee, that argument has already been advanced in that case also. The temporary irregular.
That's all.
The respectful parity, our judgment, my lord has dictated that will hold.
That will.
The judgment delivered by us.
My lord has taken note of the judgment of Uma Devi and also the Jago and subsequent judgments.
One more.
By the two,
Just, really, I can say, my lord,
He implements them.
Your Lordship may call this matter next week, so that can also apprise them about the judgment rendered by this honorable court. Otherwise, have to argue on merits. Can only apprise them about the judgment passed by this honorable.
This item, you should now implement and come back. Instead of holding them.
I have nothing more to say. Lordship will see the date of what of both the sets are same. So my learned friend, I have with great respect. The date of bringing into Archa's establishment, both those 8 and me are same one. And revised scale, other salary, same. The single judge has taken note of this fact and directed that don't discriminate, regularize. That's it. And your Lordship.
No, he's.
Fairly saying, Lord. I'm really grateful. He's fairly. He's fair. My learned friend is fair.
We have already delivered a judgment.
Fair enough. Fair enough.
What we perceive about the law.
Right. My learned friend is fair enough.
He wanted to make a distinction on the
Facts. Act is not that. Act is same. Same date. Archa's establishment, same date.
Almost all sorts of corporations.
Same date.
By now,
Except NMR dealer.
we all have covered.
Right. Lordship have covered. I have seen that. That's something else.
And other single bench
Right, Lord.
and division bench also.
yes.
There is a consistent approach of this
Consistent.
in every field, in every types of engagements which you have undertaken. Prior to 94, ban period, subsequent, after Roma Devi, after 2013 rules, after resolution 2013, everything. Almost
Then 22, 13, then 22.
even outsourcing.
Yes.
Yes. We give. Passing the same order. Now this time my brother, take a lead. I have already given my.
Yes, yes. Let me walk the past to
Already given my view.
my Lord Justice.
Division bench as well as sequence. And many other things.
If my objections and grounds be taken care of. Only that I can say only for me.
15 days.
Hello?
15 days.
15.
But
Well-
implement and come.
Implementation is not in my hands. I can only apprise them about the position of law laid down by this honorable court.
Item not 32. 10 days.
10 days.
Lordship, sheet of number 569 of 2025. There is an IA filed number 1388 of 25 for condonation of delay. There is a delay of 49 days. Your Lordship.
I am for the response. The Lordship,
Condonation tell us.
my Lord,
50 days.
50 days.
I have to say.
So your Lordship, delay may be condoned, it may be had on merit.
Yes.
And one more third, your Lordship, I have also filed one writ of it. There is also a delay. I am employed. It was, that is,
Both have to be treated similarly to neutralize.
so,
Also you will not opposing.
so delay may be condoned in both the cases.
That is good as asking.
My Lord, my second one, 6/3 of 2025,
32 connected.
47 days, your Lord.
Your
In my
50 days in her.
49 days. Your Lordship.
Same. Both condone. who have already vacated some of after terminal of the house of India, sometimes we find that they use
Yes, sir. My lord, in this matter, I have received the brief some 3 to 4 days back, including that introductory application for condonation delay. I am to give a response to that 10 days time may be done. I am for the respondent of
any days delay.
506 days delay so far the state is concerned.
My lord, the appeal filed by Valmi was in the year 2022-3. Valmi director is the secretary of the government. We had to file it in 2025, but actually both the matters are same. When 2023 first writ appeal was filed by Valmi. That is there in the list also. That organization is headed by, sorry man.
If one is sufficient to achieve the goal, then why the second?
Second was not that seriously required, but possibly
More serious. There is a delay of 500 and more days.
no, because my lord, the question
And the
is
first one is within the limitation.
yes, ma'am. That question which is going to be decided by your lordships, that is available, very much available in 2023 leading up.
Yes.
And second one is filed in 2025. Admittedly, there is a
Why? If one was sufficient, is suppose in his appeal, if the judgment is set aside, it is set aside in favor of all the respondents.
I
The
understand.
retribution.
Objection. If my land senior is filing an objection to my interim application seeking condonation of delay, that my land senior takes some time and file his reply.
For 10 days time I may given so that I'll be able to give a response to all the applications filed.
Then what to do?
In fact,
Senior file the reply there.
I am appearing with respondent 1 and 2 in the Valmi appeal, which is within limitation. I am filing it. By
No.
tomorrow.
The earlier appeal is within time.
My opinion.
So far, Valmi, yes.
Yes, within that. That was the time.
Yes.
So file within 10 days.
Yes, ma'am.
Yes,
When you are the counter.
Right.
But counter by what time?
10 days also keep it to 10 days time. So I am
Thereafter that will be. I filed within 10 days.
Madam Patnaik is also appearing. She has, he wants also.
Appear, so it may be redirected.
Names are there.
Yeah, names are there, may be redirected.
Item number 34.
Lordship, in this matter, last packet was directed to obtain instruction. Lordship, in person the closure notice that 4/24 under Annex 16, Lordship, of my rejoinder. What steps they have taken, Lordship, that is very. Lordship,
But they,
they've done nothing, Lordship.
no development.
Lordship, but Lordship, kindly see one aspect,
But
how they have.
only thing is that they have already wanted to finalize. There is a discussion with the higher authorities of the RD department.
Lordship.
That's going on for the time being. They wanted some more time so that in the interregnum, they can take a final decision.
Lordship, kindly have a glance to their counter, Lordship. For a moment, how? Under what intention they are doing, Lordship, if they have, how they have come up this honorable court, Lordship, kindly see. Lordship, kindly see their counter. That is 8/11/2024, they have filed this counter. Lordship, they have filed this counter on 8/11/2024. The same officer, Lordship, the executive engineer has filed this counter on 8/11/2024 has filed. And this closure proposal, Lordship, it is an Annex 16 on 4/7/2024, much prior to that. But while filing this counter, he has not whispered a single word with your Lordship. Lordship, can you see the intention only, Lordship? What manner they are doing this? More than 70 lakhs is still lying with them, Lordship. My entire Lordship, APS additional performance security with them. And I have been, Lordship, prevented to work out any work, Lordship, to participate in any of the tender for this tender only. And Lordship, can you see that how they have come up with this honorable court by suppressing facts, a suppression of facts, and the responsible officer, and before this court has filed such type of affidavit. He has not whispered a single word disclosure notice. Now they are saying discussion is on.
Take a decision, we can follow the decision. We can't internally wait.
The closure proposal without penalty, Your Lordship.
Without penalty is to be done. So that is what. Pursuant to the order dated 18/6/2025. This proposed with this from the the instructor received in writing the property. The concerned officials.
This Lordship kindly see last order dated 7/9/2025.
7/5.
7/5/2025. May I read it? already received the counter.
There is already a direction, what you have done, approval or not.
So Lordship, we had, this matter was heard at external Lordship. Before the Honorable, he was Chief Justice, Your Lordship, and the judgment was reserved, it was in our favorable terms, it was reserved. Now it has been released, Your Lordship. So, at that point of time, Your Lordship, it was completely argued, and
I was not there.
yeah,
So I
Lordship.
don't know what I'm.
But yes, Lordship, what has happened is that he had come on the self-same prayer before this honorable court. This court had ordered that his representation be disposed of.
You are the, you are the appellate.
And the petitioner person.
Red petitioner.
Yes.
So he has the right to begin.
Your Lordship, in last date, direction was given to the learned AGA to take instruction as to whether any decision was ever taken on the script presented by the petitioner, either approving the same or otherwise, and produce the documents in support of the same in next date. They filed the counter affidavit. I have received.
You have received.
Yes, sir. We have received the counter affidavit. Kindly see the para number 5 and 6. They are saying that the verified script were placed before the chairperson, Special Development Council, Moirvon, on dated 20th March 2019 and again 24 April 2019 for approval. However, due to engagement in election duties and the enforcement of the model code of conduct from 10th March 2019, the chairperson could not approve the scripts. The government of Odisha subsequently dissolved all the political appointments with effect from 24 May 2019. That the script were neither approved by chairperson nor referred to the collector, Moirvon, for perusal, and therefore no formal or final decision was ever taken on the script presented by the petitioner.
So you have to take, now the election is over.
Your Lordship.
After that,
Has also.
after that also chairman
This
appointed.
is a matter pertaining to the year 2018, Your Lordship. He had come before this honorable court. The honorable court had.
Madam, first thing is, there is already a direction. We have to see that the direction of the court is duly.
Your Lordship, Your Lordship, I have to apprise Your Lordship about the background, Your Lordship.
You can't.
Yes, Your Lordship,
We
because.
are referring, I am releasing, let us reduce the matter and refer to the same page. Then you will understand.
So, Your Lordship,
It's
this.
better,
Your Lordship.
both the honorable judges are available. We are going to, rather, I will suggest the constitution of the same.
Your
Let
Lordship.
him decide.
No, Your Lordship, he was before this honorable court. This court said that you go before the collector, represent. He was given a hearing.
I do not want.
He has not.
There is a direction passed on 7/5.
Yes, Your Lordship.
The direction is very,
He had said it was a copy.
paragraph 4 is very explicit.
Yes, Your Lordship. Since his scripts have not been approved, he is not liable to be paid, Your Lordship. Because there was a condition.
Have you seen the order of 7/5?
Yes, Your Lordship.
Please read paragraph. What you are saying, if the order does not say so.
But the
Please-
previous
Please
document, say so, Your Lordship.
look at the order of 7. May I read for you?
No, Your Lordship, I was
Is
the
that-
conducting counsel of this case, Your Lordship. It was placed before Justice K.R. Mahapatra's division bench, Your Lordship. Mr. U.C. Behra was.
I am referring to that page.
I am the conducting counsel, Your Lordship.
I
I
will-
have filed a wakalatnama.
No,
I had argued this case. There are other
Yeah.
documents annexed here, Your Lordship. I want to
There are two
show.
aspects of them.
Yes, Your
First
Lordship.
thing is that in paragraph 4, the
Yes.
resident says that thus this court directs Mr. Behera, Behura or whatever, Behura, learned additional government advocate to take instruction as to whether any decision was ever taken on the script presented by the petitioner, either approving the same or otherwise, and produce the documents in support of the same of the text. This was the order.
Yes, Your
We
Lordship.
wanted, show us any decisions been taken, show us the documents which the court wanted from you. So show us.
We have said that the scripts have never been approved. There are documents in the counter affidavit and there where the collector has said that the scripts were not
As you
approved.
say that you are not, so we are referring this matter to the same page. Let the bench take a call.
We are saying that
It will be taken by a bench presided over by Justice K.R. Mahapatra and Justice Ananda Chandra Behra. Both are there. They are constituting a bench. Let it go there. Argue this matter. We are assigning this matter. Better. After hearing the respective parties, it appears that certain
prove it, then of 30 days.
their lordship.
Yes, your lordship, that is there, your lordship. It's there in the counter, there are 3 affidavits filed in this matter.
See, the rest of the matters to workers.
Many.
Few matters, lordship, will last.
Do it day after day.
Grateful, lordship, grateful, grateful, lordship.